One. My name is Rodney Swink. I'm chairman of the Board of Adjustment. This is June 30th, 2023. We are continuing our appeal on the application submitted by Craig D. Justice on behalf of John and Samantha Solik, Marvin and Rebecca Bennett, and James and Angela Post regarding the December 30th, 2022 administrative development approval related to certain development at 908 Williamson Drive. We are now hearing on the merits of the case. We had opening statements yesterday. If there are no objections from either party, we will open today's evidentiary hearing with Mr. Justice. I believe you're up.
Thank you, Mr. Chairman. I'd like to call Denny Stegall.
You're still under oath after yesterday you were sworn in.
Yes. My name is Daniel Stegall.
Daniel Stegall.
Yes.
Sorry about that. Can I call you Daniel?
Yes, please.
All right. Daniel, you testified yesterday. You are the, I think, land development manager?
Correct, sir.
How long have you had that role?
A year now.
So 2022 sometime. When in 2022?
Almost a year. So July of 2022.
What did you do before that?
I was the planning supervisor, a planning supervisor.
For the city of Raleigh?
Yes.
How long have you been employed by the city of Raleigh?
7 years now.
7 years. So that's 2016?
Correct.
And as a planning supervisor, what was your role?
I had oversight of the site review team, which would include reviewing subdivisions and administrative site reviews.
So under the land development manager responsibilities, you had mentioned three things that you supervise, which was site plan, map / subdivision, and zoning. Is that right?
Site plan, which they perform subdivision review, and then there's zoning review, and then there's map review, meaning if you are submitting a recombination or dedicating right-of-way, we have a team that review maps to make sure it's accurate before being recorded.
And so from 2016 up until your promotion as land development manager, you were a planner in the site plan / subdivision section?
Yes, yes. Mm-hmm.
So you are the official who signed off on the development approval being challenged, right?
Correct, sir.
And for you, what does it mean to have signed off, that you actually put your signature on that development approval form?
That we are of the understanding that this development that was shown in the preliminary subdivision is correct, and we can conditionally approve it.
Correct, Dan.
Conditionally approve the development.
So if you could, I know you already feel like you're close to that microphone, but the microphone's not really picking you up very well. So if you could get a little closer, please.
Okay.
When you say we, ultimately you signed it, so from a personal level, you signed off saying this development plan met the code requirements.
I'm a designated signature person for our director to sign off on these development plans.
Well, to be just cut to the chase, you wouldn't have signed off of it if you thought it was in error, would you?
Correct.
Mr. Chairman, I want to go ahead and just to get it into the record, tender this UDO supplement 19 that we talked about yesterday into the record as exhibit number 4.
Okay.
That's fine. And 19 was in effect when it filed, is that right? Okay.
And just to show you, Daniel, this exhibit 4, UDO supplement 19, it says it's published May of 2022. And so that would have been the ordinance in place at the time of this application that's being challenged, right?
Maybe. I'm not certain because I follow the ordinances that are adopted and I keep file of those, but keeping up with the supplements is sometimes hard to do. So that may have been the case. So what I'm using is a ordinance, actual ordinance that was adopted and signed, and I have that. And then once a new supplement comes out, I keep up with that.
Okay, well, is there a difference between the book you're looking at and what's published to the
No.
public? Okay.
No.
And what's published to the public in this UDO Supplement 19 is a complete unified development ordinance,
That's
right?
correct.
As of May 2022, right?
Right.
That's what it says, published May 2022, yes?
Correct, yes.
And this application came in June 2022, right?
So, yeah, likely this would have been the supplement.
Okay.
Objection, that didn't come in June.
I'm sorry, objection.
Or July, when? in
I'm sorry,
this-
I didn't hear her objection.
Sorry. It's May, right? The, it was filed May 16th, 2022.
Yes.
Yes, May 16th, 2022.
Yeah, so that, I actually think it was in June, but
Okay.
Let's-
the date from probably when they put
Let's get,
Okay.
let's
Okay.
get this conversation on the record, or
So
Yeah, I want to make sure we have the right date that it was filed.
from my recollection, it was June.
Okay.
That date on the front of the
Okay.
plans is likely when they put
Oh,
the.
June 16th, 2022. Okay, got it.
I'll give you this at the end when I'm done with it. Thank you. So Danielle, I'm going to hand you what I've marked as Appellant Exhibit 5. Mr. Chairman, there's no point of spreading this out when y'all have to, this is the development plan that's being challenged, right?
Put it on the screen?
You can put it up on the screen, that for them, that'd be great. I just wanted him to have it so he can manually point things out rather than have to point on a screen.
could you enlarge that so it's full screen? Just so we might improve our, thank you.
All right. Daniel, you would agree this is the development plan that was approved, that you signed off on, right?
Correct.
And, of course, it's up on the screen. You have it in your hands. This is for a compact development, right?
Correct.
For townhouses, right?
Correct, for townhouses.
And if you look here on this plan, there's no transitional protective yard, right?
Correct.
And if you look here, there are two tree conservation areas that are noted on the plan, right?
Correct.
And then on the one that's to the southwest, you see to the left of the development property line the name of John and Samantha Solik.
Yes, I do.
And of course, in that, you see that their property is zoned R4, just like the development site, correct?
Yes.
And so for their common property line, you see that a retaining wall is proposed within 4.5 feet of the property line.
Yes.
And you see that the road, the main road that leads to these townhouses, is located approximately 10 feet from their property line. You can see that by looking at, there's a 10-foot side building setback line in a dash, and the road falls within that.
Yes.
And so as you move around to the top of the page, going to the northern boundary line, you see my clients Marvin and Rebecca Bennett's property, right?
Yes.
Their property is also zoned R4, correct?
Yes.
And you see here that the retaining wall being proposed for this development is 2 feet from their property line, right?
Yes.
And the road is even closer than it is for the Solix, right?
Yes.
Yesterday, I think Mr. Meadows admitted that, you know, the road is around 5 feet from the Bennett's property line. Did you hear that?
I don't recall that, but yeah.
All right, but there is no buffer between this development along the perimeter for the Solix or the Bennetts, correct?
Correct.
Now I'm going to step back a second and just get the hierarchy chart of city employees right, Daniel. Chair.
Mr. Chair, just object to the question about the buffer and the perimeter. If we could maybe agree to a certain language, because there is a quote-unquote transitional protective yard requirement that can be satisfied through a type B1 or B2 or a perimeter lot. And so if we can all use the same language, that would be helpful, I think, in us understanding exactly what Mr. Justice is asking and how Mr. Stegall is responding.
Mr. Chairman, it's highly unusual for opposing counsel to create in the middle of my questioning a dialogue that opposing counsel wants. This witness can say, no, the way you're describing it is not right, okay? Or when Mr. Birch wants to ask him a question, he then tries to get him to convince to his dialogue. So it's highly inappropriate for him to now interject that I've got to use particular language because that's the way Mr. Birch wants me to describe it. That's just not the way that examination and cross-examination works.
Just trying to make it clear for all of us as to what exactly he's talking about.
Well,
else we'll have to object to each one to understand exactly what he's trying to get at so that the witness actually understands what he's asking.
yesterday, multiple witnesses said there's no transitional protective yard for this development.
That's the right word.
So that's what they said. It's already in the record. So I'm just walking through that.
Again, we'll clear it up on follow-up. That's fine.
Okay.
Now let's turn to the hierarchical situation here in the city of Raleigh. When this application was submitted and being reviewed, you came in as land development manager soon after it was submitted, and during its review process, you were the land development manager as you are today, right?
Correct.
And then Jermont, and I apologize, I butchered your name, and I apologize for butchering names.
Jermont Purifoy.
Okay, Jermont Purifoy.
Yes.
Can you spell that?
Purifoy.
And what is, for the purposes of this plan review, what was his title?
Senior planner.
Senior planner. And in the three sections of things that you supervise, does he fall under someone you supervise?
No, he falls directly under me.
So he does fall under you.
Yes.
And so he's in site plan / subdivision?
Yes. Mhm.
And you said he is senior planner. What does that title denote, being a senior planner?
When you're a senior planner, you perform plan review under current planning. So reviewing subdivisions.
Okay. And then we talked about yesterday that Justin Ramada is in zoning interpretation.
He's in the zoning administrator's office. He is the zoning administrator.
Okay. And when did he become that?
Oh, gosh. You'd have to ask him. I forgot when he came on board as the zoning administrator.
Who was his predecessor?
Mark Holland, maybe? Mark Holland.
Okay.
Mark Holland.
All right. And he is outside, Justin is outside your department.
No, he's outside of my division. So planning
Okay.
department has several divisions. customer service, historic preservation, comprehensive planning, current planning, and zoning administration.
Okay. Travis Crane, now, how does he, during this time frame of 2022, what was his title?
He was an assistant director, or is assistant director.
Assistant Planning Director.
Yes.
And is he over you as well as over Justin?
No, he is over long-range planning and historic preservation.
So the Planning Director's office is not over zoning, is what you're telling me?
He's an assistant director. We have a planning director. The planning director oversees all of our divisions. At that time, we had a different division director, Brittany Waddell, and she used to oversee zoning administration as well as current planning, and that's it.
Okay. So looking at the Exhibit 5 that you have for you, the development plan, where there is a road that is in close proximity to the perimeter boundaries, and there's little bits of, what would you say is between the, on the Solic side, Daniel, in the 4.5 feet that's between their property line and that retaining wall, what space is that? Meaning, what's going to be there that the city approved?
It could be open space, just an open area.
Okay. So we'll just call it an open area. So it can be an open area there. And really, essentially, if it's in white as it goes around between the retaining wall and the exterior perimeter boundary, that's just open area, right?
Sure, yes.
So for compact subdivision developments in R4, how many times have you reviewed a plan that's proposed that's similar to this, where there is a road in close proximity to the property line, there is a small strip of open area that is next to the perimeter boundary, but there's no transitional protective yard?
How many I reviewed?
And of course, when I say you
mean the entire?
the buck ultimately stops with you as land development manager, because you're the supervisor. So in terms of your department that you administer, how many other than this, how many other plans that have this no transitional protective yard in a compact subdivision?
Objection to the use of the word transitional protective yard.
Great. Do you understand my question?
I believe I do.
Okay.
We've had a few subdivisions that come in where they're proposing a conventional lot along the perimeter of the development, and then we have some that propose a transitional protective yard. It's an option.
Well, you bring up a very important distinction. When I asked you what examples you can pull for a compact subdivision in that transitional protective yard that's mentioned for compact subdivisions, and how a developer would want to substitute for that yard a road in a tiny width of strip of open area, what other examples you had, and you started talking about conventional development. With conventional development, there is no requirement of a transitional protective yard, right?
So we're reviewing a compact subdivision.
Objection. He said conventional lots on the outside, which is one of the ways to comply with the transitional protective yard requirement. He said we've had some people provide conventional lots.
Mr. Birch?
So again, Mr. Chairman, he is trying to jump in and talk about what his dialogue wants to be.
I understand.
If this witness wants to say, no, you didn't explain it right, let me tell you what I said, that's perfectly fine. Not for him to jump in and say, well, didn't he say this?
I understand, Mr. Justice. I understand your point. And Mr. Birch, save those clarifications for when you have your opportunity. I understand your point you're trying to make, and you may object, but save the explanation, if you will.
He mischaracterized what he said, and so that's why I was coming in.
I didn't mischaracterize what you said. This is actually a fairly plain and simple case. I plainly did not mean to mischaracterize. So if you hear me say something that's not right when I talk back to you, in asking you things, right, respond back, please tell me, because I want to make sure you understand that we're on the same page with terminology and the whole ball of wax between you and me, okay? Is that fair?
I understand.
Okay. So I'll go back to my question. Can you identify any examples of other developments that you and your department reviewed for a compact subdivision where there was not a transitional protective yard and there was something akin to what is being proposed here, which is a road and a tiny strip of open area?
So each development plan that comes in is unique. We see over 200-something development plans in a year, so I can't recall any specific examples, but I do remember seeing some that come in where you've got either a transitional protective yard or you have a conventional lot or lots around the perimeter of a development for a compact subdivision. I cannot specify specific examples right now.
That's fine. The development approval was in December of 2022, right?
Yes.
We filed an appeal in January of 2023, right? This case has been pending since January to today, right?
Mm-hmm.
Yes.
Yes.
Yesterday, I heard that there's some long-standing interpretation that would support what the city did here, and I'm just simply asking you to identify one project that would support some long-standing interpretation to support what you did here. So, Daniel, I'll give you another chance to give me one name of a project. If you can't, that's fine. Can you identify one project?
No.
Okay,
I
I'm
cannot.
gonna object because what was said yesterday is that provision had been in the UDO for 10 years and it was all compact subdivisions across the city.
Well, I'm glad you said that because we'll get into it, Mr. Chairman, because that's highly misleading because compact subdivision back in the day required 8 acres as a minimum. That's not considered infill development. And 8 acres, you've got plenty of room to do a lot of things. But when you deal with a small hole in the middle of a historic neighborhood, you don't have much room. And so it's very misleading to suggest compact developments during the time that this was approved were very much similar to compact developments back in 2013. We'll walk through that in a little bit.
Okay, and to clarify my objection, I'm saying the UDO read 100% exactly the same. The words didn't change, and I'll leave it at that.
The words did change in terms of why people would use compact subdivisions, and it's a rare use before middle housing. Before it, that 8 acres went away, and you could tear down one house and jam a bunch of townhouses. But I digress. Daniel, so I think you said no, you can't identify a name of another example.
That's correct.
So in terms of this project, what is your first recollection of when the topic would have come up about the desire of a developer to not put in a transitional protective yard and instead substitute what ultimately is shown on this plan?
Ask the question again.
Can you tell me when is the first recollection you have of a dialogue that you had about this topic that we're talking about, where there is no transitional protective yard on this plan and the developer wants to substitute what is shown on this plan, which is basically a small strip of open area and a road?
So, my understanding, there's not a substitute here. You have an option. There's 2 options, or 3 rather. You can do the protective yards, which is type 1, I forgot. You can either do a transitional protective yard, or you can do a conventional lot. So there's not a substitution here. Now, as far as going back to a conversation, I can't recall.
All right, can we pull up article, section 2.3.1 on the screen? I can hand out that if we can't do it.
There you go.
And Robin, just so to expedite things, that's a supplement number 25. Is that any different than supplement 19?
That provision hasn't changed. Oh, we have a 19 of that, sorry. Sorry, there's a 19 of that.
Ma'am, I can't hear you.
I can find the 19 of that slide. What'd I do? Hold on. I don't know. I should go. She put in that, she put, where's the new one? Are you just gonna put?
In the PowerPoint?
Yeah.
Okay, okay. Okay, well, this is the whole supplement.
That's it. Yeah, okay, he's got it.
So let me just be sure I understand what you just said. You would agree that for this project, the plan we're challenging does not have a transitional protective yard?
Yes.
Objection again. You can keep going.
It does not have a transitional protective yard.
It does not have a transitional protective yard.
And I think what you said a second ago was the developer had an option to either do a transitional protective yard or to do perimeter lots. Is that right?
Perimeter lots that meet the conventional development option.
Okay. All right, so look at the heading of section 6. What is the title of that entire section?
Of section what?
C.
Transitional protective yard.
That's the title of the section. So wouldn't you think the language that followed were the options to achieve a transitional protective yard?
Yes, in the sense that you have an option to do a protective yard or conventional development option around the perimeter of the development.
Well, yes, but no. I guess what you're saying is the title of this section is transitional protective yard.
I agree.
So wouldn't it would be fair to say that the language then that follows is for purposes of satisfying the goal of a transitional protective yard?
So if you're looking for an interpretation, you'd have to speak with the zoning administrator's office.
I'm looking for the land development manager who signed off on this development plan to tell me to answer the question if you can. If you say, I can't answer the question, that's fine. So are you saying that the heading is transitional protective yard? My question is, the language that follows should be options to achieving the goal of a transitional protective yard. Yes or no?
I can't say that.
You can't say either way.
No.
Okay. All right. So you said the option is to do either a type B1 or B2 buffer, right?
Yes.
Or what did you say?
Lots must meet the conventional development option.
All right. Can we pull back up the development plan, my Exhibit 5? Now, you agree with me, Daniel, that words do matter, right, when it comes to code implementation and enforcement, right?
Yes.
So the area we've been focused at is the area that is north, on the southwest side, near the Solix line, is that area north of the TCA, the tree conservation area, as it works around the perimeter of the property over onto the Bennett side. You see that?
Yes.
And you would agree that a perimeter would be the common line that the Solix and the Bennetts share with this development, right?
Yes.
All right. Show me where there are perimeter lots.
There's a perimeter lot.
does the code say perimeter lot?
No, it doesn't.
So since the code says perimeter lots as a substitute or an option, and you just said words do matter, how does a singular lot satisfy the option of perimeter lots?
So you do have an option to put in a lot that meets a conventional development option. We've never implemented the code, this UDO section to require multiple lots along the perimeter. The city's not going to force you to make multiple lots. It's if you have a lot or lots along the perimeter of this development, it would have to meet the conventional development option.
Well, you say force. Again, words matter. So you would agree that there are not perimeter lots shown on this plan?
That's correct. There's only a lot.
And you keep saying that we've done this before. I've asked you, who have you done this before, this favorable interpretation? And you can't come up with another example at this time, right?
Correct. I do not have an example that comes to mind.
All right. Can you take this highlighter on Exhibit 5 and draw the boundary of the perimeter lot that you speak to, that you're speaking about? And this might take a couple minutes.
You can put it on that table.
Did you finish?
Yes.
Can I review your homework? So,
Can I see it, please?
now I'm going to be asking him questions about this. So there's that.
What was the question again?
The question is to draw this perimeter lot, its boundaries.
All boundaries, not just the boundaries.
All boundaries. All boundaries. If I was to try to convey this piece of property to some entity or person and need to describe it, do you understand what I'm saying? I need you to draw where the boundaries are shown on this plan. Mm-hmm. And it looks like what you've drawn is simply, you've just drawn a yellow line around the whole project. That can't be the boundary of this lot, can it?
So the lot does front on both Williamson Drive and Iredell. There may be something in here I may be missing in this section right here, but because of this lot right here.
Well, if I was to take your yellow lines,
But
yeah, I need you to draw the where the lot boundary is. So that if you say, I need to, isn't it fair to say that a lot would be a parcel that should be available for conveyance and use, right?
I can't answer that.
Well, you would need to be able to convey a lot, or could at least have the ability to convey a lot, right? Sell it, convey it.
Yes.
So are you saying, but that can't be the boundary of this, can it? If you've only taken this highlighter and gone all the way around the project, because if you conveyed that, you'd be conveying the entire project to somebody.
So this is a lot, okay, and then you've got individual lots in here. So the boundary, there's multiple boundaries here. You've got this is a boundary, and this is a boundary as well.
Okay.
So I can
Yes, I want you to.
Sure.
If my question is to draw the complete boundary of this so-called lot. All right. I'm going to I'm just going to hold this up, Mr. Chairman, and can everybody see that? Or if you can't, I'll just pass it around real quick.
We need to see it too, Greg.
Could you use that color marker, Mr. Chairman? Okay. You want to, hey, Daniel, you want to, the court reporter came up with a great solution to maybe make it brighter. Can you draw the boundaries again using that highlighter? Again, the task here is to draw the boundary of this so-called lot that satisfies the transitional protective yard requirement for a compact development.
Counsel, I don't think you should be talking to the witness while he's getting ready to draw that. We didn't talk to him. I believe Mr. Birch did.
No. I was watching. They were just standing next to him, talking to each other. Mr. Justice.
Oh, thank you. Can you go back over so you got yellow here. Can you retrace it with orange, please? So we're talking about the boundaries of this so-called lot. So if we can just do it in orange, that'd be great. All right. Thank you very much, Daniel. All right, in terms of what you draw, what you've just what you just used an orange highlighter on, did I get the boundaries right on this document that I'm introducing for illustrative purposes, this Exhibit 6? I've colored in the area that falls within the boundaries of what you just Drew, is this accurate?
I'm not certain what the different colors mean.
It's everything that's in color would fall within it. So everything in white is not part of the boundary.
Correct.
Okay. So Exhibit 6, for illustrative purposes, is accurate of the area that falls within this so-called lot that substitutes for transitional protective yard. Yes?
Yes, yes.
So I'm showing it to the board right now. So would you say that's a very conventional looking lot? If you don't know the answer, that's fine.
That Lot 18 met the standards, so we approved it.
Okay. So you would agree that there is the road in close proximity to the boundary of the properties of my clients, right?
It's in close proximity, yes.
And there's a parking area up here as well in close proximity. Is that right?
Yes.
Is there a copy of that particular?
Nope. This is for illustrative purposes. I don't have a copy. I'm sorry, Robin. All right, let me show you what I've marked as exhibit number 7, which is from supplement 19, which is the definition of a protective yard. Do you recognize, does this appear to come from supplement 19, definitions for protective yard?
Okay.
Mr. Chairman, I'd like to tender the Exhibit 6 for illustrative purposes and this Exhibit 7.
Okay.
All right, if you would just read for the record the definition of protective yard that was in place at the time of the application in question.
Protective yard, a landscape yard area which contains no buildings, vehicular surface area, loading, storage, or display service areas. For street protective yards, driveways and sidewalks necessary to serve the development may be permitted, provided that they are perpendicular to the protective yard. Protective yards include transitional protective yards, street protective yards, and Zone A transition zones.
All right, so there's a difference between a transitional protective yard and a street protective yard, right?
Yes.
And for a transitional protective yard, this definition says you're not supposed to have buildings or vehicular surface areas, right?
Yes.
So when confronted with this question about the term perimeter lots, tell me what you did to determine the meaning of perimeter lots. What you did, if you did anything.
The meaning of perimeter lots. So if we require any type of clarification, we'll consult the zoning administrator's office. In this case, we looked at the lots. That lot was the only lot around the perimeter of the site, and we deemed it a perimeter lot.
So you have a memory of you personally being somewhere talking to somebody about this very topic?
Not exactly, but I do recall our staff doing a review of the subdivision, and at the conclusion of the review, I do I guess you could say, just a quality control review to make sure everything is correct before we sign the approval document.
Well, so you're aware of staff doing something. Are you yourself aware of this topic coming before you being discussed?
What is the topic?
The topic is what the meaning of perimeter lots and whether a one open area lot can meet that definition or that term perimeter lots.
I don't recall questioning whether one lot can meet the definition of, or meet the standard for that section of the UDO that mentions perimeter lots. I don't recall a conversation like that.
So the term lot is defined in the code, isn't it?
Yes, it is.
All right, I'll show you what I'll mark as Appellate Exhibit 8. This is a copy from Supplement 19 of Article 1.5. And in Section 1.52, it's titled Lot. And there's a definition, right?
Yes.
So this is from Supplement 19, right?
Yes.
I'd like to tender Exhibit 8 into the record.
Okay.
You make sure I don't leave without. Daniel, if you want to just bring that up or something, so this is not, I'm not trying to wear you down or. All right, if you would read the definition of lot from the UDO that was in place at the time of the application in question.
Section 1.5.2, lot. A defined as a parcel of land either vacant or occupied intended as a unit for the purpose, whether immediate or for the future of transfer of ownership or possession or for development.
Okay. Is there a definition of lots in the code? To your knowledge?
Not that I'm aware of lots.
Wouldn't you agree that the plain meaning of lots would be more than one lot?
Yes.
And so for purposes of the perimeter lots, there would need to be at least two lots meeting this definition in section 1.5.2, right?
I don't agree.
Well, in terms of...
Agree.
Because you are substituting in section 2.3.1C, you're substituting the term perimeter lots with the term perimeter lot, right?
You can say that, yes.
Do you have the authority to rewrite this code? Why are you doing that when it says plainly perimeter lots?
I haven't rewritten anything, sir.
Well, you just got through saying that you would agree there are no perimeter lots shown on this plan, right?
There is a perimeter lot, yes.
My question was, are there perimeter lots shown on this plan?
No.
So you have substituted your belief that a perimeter lot would meet the plain language of perimeter lots,
Yes.
right?
Yes.
And so, for purposes of this plan, you've admitted, just because the plan shows it, that a road for a development that would fall under compact development, that would be presented with a similar language of what is a transitional protective yard, that having a road around the perimeter within a few feet is good enough, right?
No. No.
No?
No, a road would not suffice a requirement for a protective yard.
It wouldn't, because you can't have a road in a protective yard.
Correct.
And in fact, the open space standard,
Actually, a protective yard would allow breaks, so for vehicular access.
at the street,
Right. Yes.
this is around the perimeter. You can't have a road around the perimeter within a transition
I
protected yard.
don't want you to confuse the public in thinking that a road cannot be allowed in a protective yard when there's some elements of there's some site items that are site elements that can be allowed to be in a protective yard as long as it's perpendicular to the protective yard.
Well, we read the definition of protective yard a moment ago, and we can go back over it. And it said no vehicular surface area, and the exception was a street protective yard for a driveway.
Okay.
Yes?
Yes.
So for perimeter transitional protective yard, you're not supposed to have a vehicular surface area.
That's correct.
And so in terms of figuring out what this open area space is around the perimeter, this wouldn't even qualify as open space for compact development because it's supposed to be a minimum of 50 feet in width, right?
So that this area of the plan adjacent to the property, outside of that, outside of the road, you could qualify some of this area as open space. If you have at least a 50 by 50 block of open space that'll qualify, the remaining area outside of the road, could qualify as open space.
Let me be sure I understand. So I'm looking at section 2.3.1 of the supplement 19 that would have been in effect at the time of application. And in subsection B2, well, actually, the whole section B is open space for compact development. You see that?
Yes.
And the requirement is, in order to qualify as open space, you have to, it says 50 feet minimum.
Mm-hmm.
That means in all regards where you say there's open space, it has to be 50 feet minimum.
Mm-hmm.
Yes?
Yes. Mm-hmm.
So around the perimeter for the Solix and Bennett's, this area that we're talking about where there's a road, that wouldn't qualify as open space, would it?
So the road wouldn't qualify as open space. However,
Did you say the road would?
I said the road wouldn't qualify as open space. So when you look at that section of the code, it says 50 feet. 50 feet doesn't necessarily have to be in both directions. Okay, at least one portion of open space would have to be 50 by 50. The remaining area of that open space can be 50 feet wide. You can measure that linearly or in one direction.
If there is 2 feet, as there is over by the Bennett's, of an open area between the perimeter boundary and the retaining wall and the road, does that space qualify as open space for compact development?
It could, because it's 50 feet in the other direction.
50 feet in the other direction?
Yes.
The length?
Yes. Mm-hmm.
It says width.
Right. So width can be measured from a different perspective. You're saying 50 feet from the property line. That doesn't necessarily have to be that way. It could be-
Is there any discernible standard for where you measure width in the context of the 2 feet that I'm talking about for the Solix and the 4.5 feet that I'm talking about for the Bennett's?
We have a description for how lot width is measured.
Yeah, I'm asking about this open area, how you would measure its width.
So there isn't a description of how open space is measured. As long as it's 50 feet wide.
That's my question. Are you saying that a 4.5 open area for the Solix there on the plan and a 2-foot area that's denoted for the Bennett's, are those areas 50 feet in width?
In the other direction, yes.
So you mean up and down?
Yes, in this case. Well, if you look at the property line to the north, going east to west, it could be measured as 50 feet wide. But I believe you're measuring it, I can't really see, 4 feet or 2 feet from the property line. No, it's not 50 feet. But in the other direction, it is 50 feet and could qualify as open space.
So am I standing here, I am how wide? And I'm okay if you want to say something derogatory. My width is my waistband, right?
Yes.
My width is not my height, is it?
No.
You're turning this open space width to count basically its height or depth.
There's not a specific way to measure open space described in that UDO section.
Is one point of open space, to have open space, require open space, is to provide a buffer for a neighbor?
Ask the question again.
Is one purpose of an open space is to provide a buffer for a neighbor?
I can't answer that. That would be an interpretation that I have to rely on the zoning administrator's office to provide.
So you don't know?
No, I wouldn't know that.
All right. So for purposes of this interpretation, and the interpretation of that the developer satisfied the compact subdivision requirement of subsection C by having this one open area lot where the boundary went around the perimeter, which is really the black and pink on this illustrative exhibit 6, right? It's the road in the pink area.
Yes.
So the measurement of that so-called lot is at the street, right?
Yes. The measurement of the lot is at the street.
And it has to be
The width.
how wide?
I forgot how wide it has to be. I think 65 feet.
65 feet. So to be sure everybody's clear of this, you would say that the perimeter lots or transitional protective yard is satisfied in these developments whenever a developer is able to take 65 feet of space up by a road, let's just, of an open area, and then connect it all the way around the perimeter with other open space, regardless of width, or regardless of how much distance between the neighbor and the project.
You're conflating several different UDO sections. You've got lot width. That's its own separation. That's its own standard. Lot width has to be measured at the primary street. That's one standard. Then you've got open space. It has its own standard of 50 feet, which it meets that standard. And then you've got the protective yard. The protective yard has its own width standard. There's a UDO section. I forgot what UDO section it is, but the protective yards have their own width that would have to be applicable if they were pursuing a protective yard here. And I believe you are trying to take multiple code sections and mix them up.
So what I'm trying to understand from you, the consequence of this interpretation, is if I'm a neighbor in a single-family detached home, happens, let's just say it's in a historic neighborhood, like Hayes Park, and someone comes in and wants to tear down the historic home next to me and replace the one home with 17 townhomes, or Lord knows, however many townhomes. And at the end of the day, the separation between the neighbor, the single-family home, and this development is what I'm talking about. Separation between the neighbor, the Solicks and the Bennetts, and this project. And what is the required separation? And that would be what Transitional Protective Yard Section C gets into. It's either a vegetative buffer or it's perimeter lots, right?
Correct.
And so for this purpose, the separation for the Solicks and the Bennetts from the roads, for the main road, is less than 5 feet, right?
Okay, yes.
So what would preclude any developer, according to this interpretation, from putting the townhouses themselves within, there's a setback that would apply to the perimeter, right? Building setback.
Yes.
So the building setback, they could put a townhome within really 10 feet of the boundary line with no buffer.
I can't recall what the setbacks are for this development.
Well, we can look at the compact development area. Don't you have that? If you don't have it memorized.
And well, one thing to remember, we're only looking at lots for this development. We're not considering setbacks at this point with the buildings.
I heard that argument yesterday. What I'm trying to get to is the consequence of the city's interpretation. So for compact developments, townhouses, two point 2.3.4 of the UDO. This is supplement 19. And I'm just showing this to refresh your memory. For R4, the side lot setback is how much?
10 feet.
10 feet.
Side boundary.
Yeah. And so again, a townhouse, with this interpretation, a townhouse could be located the 10 feet from the side lot line. And the only requirement, there would be no requirement to put in vegetation so long as that within that 10 feet of distance is connected to property that borders the street frontage by 65 feet.
Correct.
And so for road purposes, how far does a road have to be off a perimeter boundary?
I wouldn't know that.
Excuse me?
I wouldn't know what the setback for a road would be. I don't look for setbacks on the road, for the roads.
Well, for compact developments, you don't know if a road could be right up on the property line?
So we have another department that would review the drive aisle for the development.
So this provision that we're talking about of Section C for compact development that deals with transitional protective yards as a heading, that criteria or those requirements apply to all compact developments wherever they may be in the city, right?
Yes.
They also apply to conservation developments, right?
I believe so.
Now, according to Supplement 19, you see this building types allowed by district in section 1.4.2. Do you see that?
Yes.
Townhouses are permitted in R2 as a compact or conservation development, right?
Yes.
And so this interpretation you're talking about would apply to your R2 zones as well.
So I don't provide any interpretation, sir. We rely on the zoning administrator's office to do interpretations.
You're the land development manager. This table says townhomes are allowed in R2 that would have to be part of an approved compact conservation or cottage court development. That's what it says, right?
Yes, yes.
So I just simply then summarized that this interpretation of what a transitional protective yard would potentially affect these R2 areas of the town where some developer wanted to do a compact development. Yes?
I'd have to see a development plan to make that determination.
So they apply, this interpretation would even apply to R6 areas where there's an apartment building. Right?
So from my understanding, this is illustrative in our Unified Development Ordinance. We rely on the use chart to determine what developments are permitted in what zoning districts.
So I'm not sure. Apartments are allowed in R6 if they're in a compact development. Yes, according to this table?
Yes, according to that table, yes.
In your R2, R4, and R6 districts, there's a lot of those in the established areas of the city of Raleigh, right?
I don't know.
All right, let me show you what I'll mark as Exhibit 9. Exhibit 9 is a representation of zoning districts in the city of Raleigh, right?
This is your exhibit. I don't know. I mean, I'm just going off what you're showing me.
Well, the city of Raleigh has a trademark, right, that identifies the city of Raleigh thing, which is in the left side of this document, right?
Okay.
Yes?
Yes.
And were you privy to our public records request that we sent out asking for public records of the city of Raleigh?
No, not that I'm aware of. No.
Okay. So you wouldn't know what this numbering then means at the bottom of the page of this document.
This number right here?
Yeah.
This number right here?
Yeah.
No, I wouldn't be aware of that, no.
Right. And really, I'm using this document for illustrative purposes as well. This is exhibit number 9. Yes. I'd like to tender this document as for illustrative purposes as well.
Okay.
Just for the record, we don't know what date this is. I do know we produced it, but I don't know what date this map came from, so just for the
So
record.
this immediately preceded the middle housing 1 change, but this is what we got in as part of our public records about this. So on this plan, on this document, there's a code, a color code index that shows properties that are demonstrated as being zoned are residential 2 or residential 4 or residential 6, right? You see that in the code index?
Yes, I do.
Or the color index, excuse me. And that's a lot of the, where's the belt line on this? Can you see the belt line?
Yes, I can. Yes, I can.
A lot of those colors are within the Beltline, right?
Yes.
These are well-established residential neighborhoods that have been around for decades, right?
Yes. Yes.
So this interpretation that you're talking about, where you don't have to have a vegetative buffer or a transitional protective yard, just walking through the table we just looked at, would be applicable for any developer who wanted to do a compact development or a conservation development in R2, R4, or R6, right?
Yes.
So going back to Exhibit 5, this document. For purposes of the buffering or transition area, the area between my client, the neighbors of this project, and the project, the buffer transitional area, describe the difference, if you would, between what a conventional development would have to show versus a compact development.
So, well, a compact development would have to show open space, and then they would have a higher density count, potentially a higher density count. Conventional developments would not be required to do a transitional protective yard.
Okay. So let me break down what you just said. You have to have an open space that qualifies of an acre in this case, right?
Yes.
Predominantly that space is in the middle between the townhouses, right?
Yes.
And in fact, for purposes of calculating open space requirements, you don't count the road, right?
Right. Right.
And did the city count these strips of open areas as part of the meeting the open space standards for this development?
The strips, you have to show me if you could point it out to me.
These are the 4.5-foot strip on the Solex side and the 2-foot strip on the Bennett side. Basically between the Bennett's property line and the retaining wall and the road and the Solex side between the common line and the road.
If I'm reading the plan correctly, those areas weren't counted. We typically ask applicants to hatch or provide a pattern for the open space, so it could be so we can distinguish it between other site elements on the plan.
All right, so
I'm sorry, let me interrupt. I didn't, you said weren't, were not, right?
Weren't what?
They were not counted. I want to make sure I understand you.
I don't believe so in this
Okay.
case.
And you make a great point, Daniel, that this plan delineates uses or things that the space needs to be devoted to meet certain standards. The open space required of this developer is what you said was hatched, right?
Yes.
So this garbage space around the perimeter is just open area. There is no category for it to fall within.
Yes, so that lot 18 was viewed as a conventional lot.
I understand what it was viewed, but for purposes of saying
It's
it's open space or
Just
it's a building lot or something,
it's an open area. Yeah.
yeah. Do you have a definition in your code for just this garbage space that's open area?
We definitely don't have a definition for garbage space.
This open area we're talking about that doesn't qualify as open space, doesn't qualify as a building lot,
But it qualifies as a conventional lot.
only because it's connected, gerrymandering around, it's all connected
No,
some way.
because it meets the minimal dimensional standards for a conventional lot.
Mr. Chairman, can we take a 5-minute break?
Yeah, and as we do that, could you just be clear what Lot 18 you were referring to? You
It's
mentioned,
the lot is outside of the townhouse lots.
The, Mr. Chairman, that is, everything in color is Lot 18.
okay, good.
Everything
Correct.
orange, pink, and black is
Thank
Lot
you.
18.
Okay, yes, and yes, it's a great time. Let's actually take a 10-minute break, please.
Board members, I just want to let you know that we did get some coffee delivered, so.
We're back with you, sir.
When we take a break, we had Daniel on the podium. Daniel, let me know when you're ready. You ready?
Yes, yes.
Okay. Daniel, at the break, I noticed that you were over there conversing with the city attorneys and the developers' attorneys. What were you talking about?
Objection to the extent that I'm talking to him, I'm his lawyer.
Not when you talk to them in the same room with the developer's attorney, that there is no privilege for that. So you were over there conversing with the development team and the city attorney team. So what were you talking about?
I was talking about this case.
Were you talking about specifically the transitional protective yard issue?
No.
What were you talking about this case?
Talking about points that I need to make while I'm discussing this with you.
Okay. To clear up, do you have Exhibit 8 in front of you? This is the measurement, Article 1.5. Do you have that in front of you? Going back to the discussion that we were having, where I used my height and my width, and you were talking about width, just for clarification, that for lot width purposes, for this lot 18, you're measuring the width at the street, right?
Correct.
And so this space here is width, right?
Yes.
And that would be, what on this plan, is that east to west?
Yes.
So as you move up here in terms of width, when you're looking at the border of Solic, or you're looking at the border of Bennett, the width would have to be measured from east to west, from their property line into the project.
For lot 18, when we're looking at lot width is measured at the primary street. That's
And then
different. Pardon me. That's different when you're reviewing open space, the width of open space.
I'm talking about, we've already determined that this space around the perimeter doesn't meet open space, but you said it meets a lot. So I'm just asking you, it isn't a correct statement that for this so-called lot, you're measuring it east to west, so you would measure its width from the Solix property line in, yes?
From the side property lines in.
That's the Solic's property line, the common line, correct?
No, we would measure at the road. Again, you would measure at the primary street, which is along Williamson Drive, from the end of the property line inward, end of the side property line inward. So you can measure from east to west there. At the
You
street.
can. Can you just come over here and demonstrate the board in this area where the Solix property is, and you're saying that everything in color is part of the lot. Where is it? What is the width along the Solic line?
So, what are you trying to measure?
The width of the lot at that
The
point.
width of the lot is
Yeah.
measured at the primary street.
And that's it.
Yes.
And then there is no more width.
Then you have an area that you have to measure, because it's an open lot, so you'd have to measure the area of the open lot.
We're at 10, right? All right, Daniel, I'm going to show you what I'll mark as Appellant Exhibit 10. You'll take that. Thank you. This is section 1.4.2 of the UDO that was in place with supplement number 2, right?
Sure, yes.
According to this Exhibit 10, it says the effective date of this is September 1st, 2013. Yes?
Yes.
Mr. Chairman, I'd like to introduce Exhibit 10.
Okay.
So according to Exhibit 10, Daniel, you would agree with me that at this time in 2013, that in R4, that a townhouse building would be allowed in R4 only as part of an improved conservation development, right?
Yes.
All right, I'll show you what I'll mark as Appellant Exhibit 11. Exhibit 11 is from the same supplement number 2 version of the UDO that's in place in September of 2013. And this is Article 2.4 for Conservation Development Option, right?
Yes.
I'd like to introduce Exhibit 11 into the record.
Accept that.
In 2013, for R4 zone properties, if a developer wanted to do a townhouse, he would be limited to going through the conservation development standards, right? At that time.
Yes.
Yeah. And according to Exhibit 11, conservation development standards for R4 said that the minimum site area had to be 12 acres, right?
Yes.
That's hardly infill development, 12 acres, right?
Yes.
And it would require 40% of the property to be set aside as open space.
That's correct.
As you sit here today, I don't know if you had time during the break, can you identify a conservation development in R4 in the city?
I couldn't think back and remember if we had one. We may have, but I can't recall.
let me show you what I mark as appellant Exhibit 12. This is from supplement number 12 of the City of Raleigh UDO that was in effect in July of 2021. Isn't that right?
Yes.
This is for section 1.4.2 that regulated building types allowed by district, correct?
Yes.
I'd like to introduce Exhibit 12 into the record, Mr. Chairman.
Okay.
According to this Exhibit 12, from 2013 up until 2021, July of this supplement, townhouses were not allowed in R4 in a compact development. Right?
Ask the question again.
So according to this table, let me reverse my question. In R4 zoned areas, townhouses are allowed in an approved conservation or cottage court development, right?
Yes.
Not compact development, right?
According to this, yes.
All right, let me show you what I mark as Appellate Exhibit 13. Appellate Exhibit 13 is the corresponding section of the Conservation Development Article, Article 2.4, that was in place as part of Supplement 12 in July of 2021, right?
Yes.
I'd like to introduce Exhibit 12 into the record.
Okay.
12 or 13, Mr.
13, I'm sorry. It is 13. Daniel, in July of 2021, at this time, for conservation development, the requirement of having 12 minimum acres as part of a site is still in place, correct?
Yes.
As well as the open space of 40%.
Yes.
And all right, let me show you what I mark as Appellate Exhibit 14. So Exhibit 14 is the Supplement 12 standards for cottage courts in Section 2.6.1, right?
Yes.
I'd like to introduce this exhibit into the record.
Okay.
Just a quick objection for the record. Each one of these, Mr. Justice was very adamant that we have all parts of the ordinance that we were using. These are isolated. This is just one provision out of Supplement 12, one out of Supplement 2. And so we don't have other provisions that would explain this. So he can introduce them, but we don't have any context from the rest of these ordinances to know the other parts or what they said.
Mr. Chairman, to forecast what I'm doing is the city made a point that the interpretation in question in this case has somehow been a longstanding interpretation. And what I'm pointing out is that the provision in question was part of a conservation development, which required 12 acres minimum, a large piece of property. Generally, the developer has a lot more flexibility in terms of what they put in on a piece of property than an infill development of 2 acres. So I'm just walking through the legislative history to show you how the door was blasted open with Middle Housing 1. That's all I'm doing. If the city wants to offer up any other, I assume they have links to all of these things.
Well, we do, and just for the record, that section that we talked about having the interpretation is Section C, which each one that you hand up has that same interpretation. So that was the point.
Right, that interpretation for a developer on 12 acres. Not, and again, if the city can point out one example where the developer ran out of room on 12 acres and put the road and no transition buffer yard along the perimeter, I'm happy to hear about that.
That is not relevant to whether this plan conforms to the current UDO, which is the question before us. So this is legislative history and is actually showing that the same provision has been there. But just to move things along, the question is, does this plan meet the UDO when it was filed? And you can keep going.
Thank you. And the answer is no. All right. So cottage court developments. Have you had an opportunity to be presented with a development plan for a cottage court?
Yes, we have.
Okay.
Yes.
And can you give me a name?
I can't recall right now, but I've seen some.
Okay. The building type allowed here, according to 2.6.1, is limited to 2 units per building. You see that?
Yes.
So you couldn't do triplexes or quadruplexes, correct?
Well, not necessarily 2 units per building. If you look at the building types allowed, it says detached, attached, and townhouse 2-unit maximum per building. So a detached house wouldn't have 2 units in it.
I understand that. I went in the opposite direction. I said you're limited to 2 units in a building, so you would not be able, with this option, to do triplexes or quadruplexes.
That's correct.
And this development plan you approved for Williamson Townhomes would include the ability to do triplexes, right?
No, not this development, no.
Well, if you go back to look at, you're saying for Williamson, if you go back and look at Exhibit 5, Exhibit 5, you have that in front of you, the development plan? You don't have sort of open area breaks in these lots, where these lots are basically jammed in together, where there's 3 lots sharing a common property line, right?
Right, there's 3 lots sharing a common property line, a common property line, yes. Triplexes are not mentioned in the UDO, so we would be looking at this as a townhouse, lots that are set up for a townhouse development.
How many units can be, dwelling units can be attached as part of a townhouse?
I'd have to look at the building description on that.
All right, let me show you what I'll mark as appellate exhibit 15. Appellate exhibit 15 is UDO supplement 13 that's published August of 2021 for section 1.4.2, building types allowed by district, right?
Right.
I'd like to introduce exhibit 14 into the record.
I believe this is 15.
Says 15.
now?
15, I'm sorry.
Yes.
15. Is that all right, Mr. Chairman? I'm sorry, I didn't, is that okay?
Yes, sir.
Okay, thank you. So exhibit 15, Daniel, this would be after the middle missing housing number 1 changes, right?
Potentially.
Well, the
It says August 2021, but I'm not certain if it were before or after the 5th.
Okay, well, we'll walk through the ordinance itself in a second. But now, in August of 2021, townhouses are allowed in R2, R4 in a compact development.
Yes.
All right, let me show you what I'll mark as appellate exhibit 16. This is a copy of missing middle housing number 1 ordinance that went into effect or was adopted in 2021 and became effective August 5th, 2021, right?
Yes.
Mr. Chairman, I'd like to tender exhibit 16 into the record.
Yes, sir.
So let's turn to section 13 of this exhibit, which is on page 10 at the bottom right-hand corner. Are you there? So
Yes.
Daniel, with these changes, in this middle missing housing 1, for compact developments that are now introduced as a possibility for townhouses in R4, a change occurred where the gross site area minimum of 8 acres was deleted, right?
Yes.
And then as you move over to conservation development option, which is on page 16,
You said page 16 or section 16?
page 16 at the bottom. It's section 21. And actually, it's I'm looking at the table itself, right above that. But you see on page 16 of this ordinance is a discussion of changes to the standards for conservation development, right?
Yes.
And the 12 acres is deleted as a requirement.
Correct.
So, of course, the effect of those changes to delete the minimum acreage required being 8 acres for compact developments or 12 acres for conservation is that the tool is more flexible in its utility for infill development, right?
You could say that, yes.
Yeah. So this is happening in the summer of 2021, right?
This text change, yes.
Yeah.
Being, yes, going to effect, yes.
And you've already said you can't identify an example of a conservation development or a compact development other than the one in question. You don't.
Not off the top of my head, I can't.
Before I leave this the middle missing housing 1, it did not change the transitional protective yard requirements for a compact development, did it, in R4?
Correct.
It did remove, for compact developments in R6, a transitional protective yard, right? I guess actually it allowed townhouses as a conventional development in R6.
Yes, I believe so.
And I meant to ask you this before because you were talking about the difference between compact and conventional. Compact has a transition protective yard, right?
As an option.
Yep. Well, we'll get into that, but section C says transition protective yard, and whatever the terms you believe say, it's subsection C is still there for compact developments, yes?
Yes.
The trade-off is compact developments have more density, right,
Yes, they do.
than conventional.
Yes.
Meaning, wouldn't it be fair to say that the transitional protective yard for a development, would it be even more necessary the more dense that a developer wants to put in on a site?
Objection, that's a legislative call by the council, it's not his.
If he doesn't have an opinion or anything like that, that's perfectly fine. This is,
I'm entitled to object. You objected to me quite often. I'm trying to just put it for the record, not to argue.
actually, I haven't objected that much. But do you have, can you say either way about that?
Mr. Justice, you're correct. I don't have an opinion. If a development comes before staff, if it meets the standards, we will approve it. If it doesn't, we will deny approval.
But the reality is despite the rush to allow more housing,
Despite the what, sir?
the rush to allow more housing or the need for more housing, that's part of Middle Housing 1. At the end of the day, for R4 compact development, they retained the requirements of subsection C for compact developments.
Yes.
Madam Clerk, am I at 19? 17. All right, let me show you what I'll mark as Appellant Exhibit 17. Appellate Exhibit 17 is a compilation of various City of Raleigh public records that are in the main minutes of meetings of committees and city council, right?
Mr. Justice, I assume you're asking this to be introduced.
Yes, I'm just having him say that he would agree that this is a compilation of City of Raleigh public records in the main denoting minutes of meetings.
It appears to be.
Okay. Yes, I'd like to introduce this in the record.
You may.
So Daniel, you were employed by the City of Raleigh in 2019.
Yes.
The first document that's part of this Exhibit 17 is a set of minutes from the Healthy Neighborhoods Committee. Do you see that?
Yes, I do.
And there's a discussion here about transition areas between residential areas and mixed-use buildings. If you want to scan over that and see if that's really the overview of what's being discussed.
Okay.
Let me know, is that correct? That's what it appears to be. Yes?
Yes.
So on page 2, what I've highlighted, Mayor McFarland, that's the predecessor to Mayor Baldwin?
Yes.
Okay. Mayor McFarland, and I'll just read it so we can expedite this, stated the main concern she has is the need to have some way to protect the old historic homes along Hillsborough Street in similar areas from being torn down and replaced with offices, townhomes, and condos. Do you see that?
I do.
Mr. Chair, excuse me, Mr. Chair,
Yes, sir.
just want to object to all of this and this questioning. These minutes that have been provided are from committee meeting in 2019, then council in 2015, so we would object to relevance. This is before Missing Middle 1.0 was even considered, and we don't understand how this relates to whether our subdivision plan complies with the code in effect when we applied.
So, Mr. Chairman, their development plan doesn't comply with the plain language. But it's important to understand that despite this rush to have more housing, the City Council preserved transition protective yards for R4. And I'm just simply walking through what city leaders have said about transition areas and their importance. because Middle Housing 1 didn't do away with that importance for R4. And those are the importance of that, and the purpose of that is meant to protect my clients as neighbors to a compact townhouse development. So it's very common to go through legislative history. I'm
I'll
trying to,
reiterate, this is not, these are not the city council that even passed missing middle, nor did they authorize it, nor does it have anything to do with what was passed. And then keep going.
Objection noted.
all right. If you go further into the document, there's a set of minutes from the city council dealing with UDO in 2015, and there's a discussion. If you go through this, you'll see a highlighted area of discussing transitional protective yards and landscape regulations. Do you see that?
What page are we looking at?
Page 4 of the October 12th, 2015 minutes.
Yes, I see it.
And I'm not gonna have you read through it all, Mr. Chairman. I would just request that the board scan through the intent of transitional protective yards here. But it's noted at the bottom of page, Daniel, is it not, that the intent of transitional protective yards is to protect neighborhood character.
Yes, that's what it says.
Again, we'll object. We'll bring to the board's attention that this is a provision from the old code, pre-UDO. That's what's being cited here from section 10-2082 was the legacy code before 2013. So again, just would object to relevance.
Mr. Chairman, it's whatever suits them is good for them, but whatever doesn't. If you recall, they said there's been this longstanding interpretation going back to 2013 about this same topic, which deals with transitional protective yards. So that's what they said yesterday, and that's what they'll probably say later. So I'm only addressing the fact that when you're talking about that history of transitional protective yards, what's the leaders of the city talking about in terms of the importance and objectives of those very areas? They're the ones that raised it by saying they've had this long interpretation going back to 2013.
One moment, please.
Yeah, I'm not quite sure if this is for City's Council or Mr. Justice, but just a point of clarification for me, it seemed like this discussion is in the context of a transition between residential areas and mixed-use buildings. But I guess I'm confused. I didn't realize that townhomes were considered mixed-use building. Aren't we going from residential to residential without regards to our particular case?
The first set of minutes dealt with the transition between residential and mixed use. These set of minutes just talk about the intent of transitional protective yards and are not specific to between mixed use.
Well, so the townhomes are not mixed use. Is that right?
That's correct.
Yeah, townhomes are not mixed use, but they're mixed character, requiring a transitional protective yard for compact developments.
Yeah, I'm just sorry. I just wasn't familiar with the transition yards between residential areas.
Mr. Chairman, as we all know, this board is going to give weight to whatever they want to give weight to, as long as there's a scintilla of reasonableness to what I'm offering. They, again, suggest there's this long history of an interpretation going back to 2013. I'm just trying to fill in the gaps.
Yes, sir.
And then on page 5 of the October 2015 minutes, Daniel, you'll see there in the middle, it talks about if the intensity of use, and this is highlighted, if the intensity of use is about the same, there is no TPY. The higher the intensity of the use next GU, the more light and air and protection from impacts it has to give you. Do you see that?
Yes, I do.
And I guess there is some question about townhomes are not necessarily mixed use, but townhomes are a multi-family type product that are not single family, right?
They're not single family. We deem it as multi-unit living.
Thank you. Which is a different use than single family.
Yes, it is.
And then later on that same page, it says the TPY will come into effect when the neighboring property wants to redevelop more intensely. You see that? Same page?
Yes.
And then turning to the last document that's part of this compilation, there's an article about from the Raleigh Planning Department, and you'll see what we've highlighted here from 2011, and it's called UDO Day 14, Making the Transition, Getting to Know Your UDO. Do you see that?
What page is that?
So it's the last document. So if you go to the very end, it's the last 2 pages of this compilation. See that?
Yes.
And then it says Christine Dargis, UDO project manager with the Raleigh Planning Department, explained, in the current code, transitions are referred to as transitional protective yards and are used between two uses of different impacts, such as between a gas station and a church. You see that?
Yes.
And then it goes on to say the UDO will soften the edges of higher density areas so they blend with lower density areas. Do you see that?
Yes.
And then you finally see what her comment is, that these transitional protective yards are really about neighborhood protections. Do you see that?
Yes, I do.
Now, for all those characterizations that we went through from the mayor and various folks associated with the city, is there anything that you disagree with about the purpose or objective of a transitional protective yard?
So again, that's that you'd have to form an opinion, and I don't have an opinion. If the development comes before my staff, we're looking for compliance with Unified Development Ordinance. We don't have an opinion.
Well, at the end of the day, if you said to a developer, along the perimeter of a compact townhome development, put in a vegetative buffer of, what's the width of a vegetative buffer, B1, B2?
I don't know off the top of my head.
Is it more than 10 feet or?
Yes, it would be, yes.
All right, so of a fairly significant width of a buffer with vegetation
Yes.
all around the perimeter, that's fairly costly and expensive, wouldn't you think?
Maybe, I don't know.
It's a price of doing development, but
Yeah.
there's very much an expense associated with it.
There is. Yes,
And you understand that this expense is not only in the cost of buying the vegetation and planting the vegetation. That's part of the expense to a developer, right?
Yeah, yeah.
It's also devoting that area to something other than an actual townhouse
Yes.
or a road.
Or a road.
And so when presented the option of having a 4-foot strip of really area that you can't even classify as open space and a road, why wouldn't the developer pick this 10 times out of 10 as the option? Objection. If you don't know.
I don't know.
Okay. So for all those things that we went through with this last exhibit, about neighborhood protection, protecting the neighborhood character, softening the transition, tell me how this option that you said was appropriate, the way they did it on Exhibit 5, even remotely serves any of those.
So I didn't say it was appropriate. I said it complies. It complies with the Unified Development Ordinance.
Well, isn't it fair to say that if you had conventional perimeter lots, then those would be lots around the perimeter, lots, multiple lots, that would have to be of a certain size,
Yes.
right?
Yes. Mm-hmm.
And the size requirements, you can't even do a townhouse lot conventional in R4, right?
I'd have to look back at the Unified Development Ordinance.
This table from Supplement 19.
No, at that time, no.
No. So in order to have conventional lots of a conventional nature around the perimeter, these would have to be lots that would be attached for attached housing or detached housing, right?
Not necessarily.
Well, not necessarily, because you said that this open area, one lot qualifies.
Yes, the one lot qualifies, yes.
But if they were to put in attached lots around the perimeter for attached dwellings or for detached dwellings, those lot sizes would have to be 10,000 square feet all around the perimeter, right?
Depending on what the UDO says, if it complies, we would approve it.
Well, we can go through, again, the lot dimensional requirements for attached and detached are 10,000 square feet minimum.
And if they were conventional lots and they meet the standard, then we would allow it.
It's fair to say the developer would not have been able to get 17 townhomes in this project if around the perimeter were lots for detached or attached dwellings. Just common sense of space.
Maybe. I mean, I'm not a designer, so I couldn't tell you that.
Objection, that's not what he reviewed.
Madam Clerk, are we at 19? 18, okay. All right, let me show you what I mark as appellant 18. Appellant 18, this would be a communication that's part of the city's public records, would it not?
Yes, it appears to be.
I'd like to introduce Exhibit 18 into the record.
Okay.
Do you know Dean Raines?
I do not.
Do you know Roberta M.K. Fox? Do you know it looks like Roberta Fox?
I don't know her, but I know of her.
And who is she?
She is a former employee of the city of Raleigh.
Okay. Do you know C.J. Mann?
No.
Okay. Well, in here, it speaks of transitional yards between townhomes and single family. Do you see that discussion?
Is there a specific line you're wanting me
It
to
says,
look-
why include transition yards between townhomes and single family? Do you see that?
Yes, I see it.
And it says the intent is to soften impacts and concerns to adjacent single family homes, low density neighbors.
Yes, I see that. Mm-hmm.
And I guess you don't have an opinion about that, whether the
No.
transitional protective yards actually serve that purpose.
I do not have an opinion.
Okay. All right, let me show you what I mark as appellant 19. Appellant 19, this appears to be a city public record communication from Kenneth Bowers to a Lewis, and you probably need to tell me how to pronounce Lewis's last name, but it's Buonpane.
I don't want to butcher Lou's last name. So,
You know Kenneth Bowers, right?
yes, I know Ken.
And who's Kenneth Bowers?
He's the deputy director of the planning department.
Okay, and this is a communication where Kenneth Bowers is the author, right?
Yes. Yes.
I'd like to tender Exhibit 19 into the record, Mr. Chairman.
Okay.
So this communication is June of 2021, right?
Yes. Yes.
And so this would be just prior to the adoption of the Middle Housing 1 ordinance, right?
Correct.
And this appears to be a PowerPoint presentation that Mr. Bowers has prepared relating to this topic of Middle Housing 1 ordinance, right?
Yes.
And I just want to, if you go to the third page, it talks about the recap of the Planning Commission's recommendations. So for legislation to be ultimately adopted, it's got to go through the Planning Commission to give an advisory opinion to the City Council, right?
Yes.
And here on this page 3 of this exhibit, which would be page 2 of the PowerPoint, to recap the requirement of protective yards are being proposed for elimination in R6 and R10, right?
Maybe I'm not seeing
So
what you.
the title of this is Recap of PC Recommendation. It's page 2 of the PowerPoint, page 3 of the exhibit itself.
I see.
It says townhouses in R6 and R10, no requirements for protective yards, buffers.
Yes.
So from this, and looking at the Middle Housing 1 ordinance itself, the transitional protective yard, the choice was made to eliminate that protective yard buffer for R6 and R10, but to retain it for R4, right?
I don't know, sir.
Well, I assume the middle housing document, the ordinance that we went through and walked through, will speak for itself.
Okay.
But you can see from this document, they're referring to townhouses in R6 and R10, but not in R4.
Yes.
So going back to the UDO, section 1.4.2, which is building types allowed by district,
Yes.
this is supplement 19, which is the ordinance in place at the time of the application in question. This allowance for townhouses in R4 is qualified by number 1. You see that 1?
Yes, I see the one.
And it says in the footnote for number 1, what does it say?
In R4 and R6, townhouses and apartments are allowed as part of an approved development in the TOD overlay.
Okay.
TOD.
Capital T, capital O, capital D overlay. The project in question, the property in question, is not within a TOD overlay, is it?
Correct, it's not.
So with the qualification that's on the very table that would have been in place at the time this application was submitted, and this is not a TOD overlay, then why are you allowing this townhouse development at all?
Because the chart, not only the chart, but the use for townhomes in R4 were permitted.
Even though the chart says it's part of a TOD overlay.
Yes, that's a separate footnote.
Separate footnote that says TOD overlay.
Yes.
All right, let me show you what I'm marked as appellate exhibit 20.
Is that board you just held up an exhibit?
It is, this is being held up for ease of grabbing it, so we didn't have to put it up on the screen, but this is, the board I keep handing up is from UDO Supplement 19, and it's
I
the,
understand, I just asked if it was an exhibit.
oh, it's in the record.
I understand understand that. Okay.
It's in the record. And in fact, it's part of my Exhibit 4, I think, is the UDO supplement notebook.
Right, you just keep asking him questions, and he doesn't have it in front of him. You just wave the board. So I just want to make sure he knows where to refer to it if he needs to look.
Daniel, if I'm waving something around and you don't see it, and you're confused by what my antics may be, just let me know. I'm not trying to confuse you. Okay. Exhibit 20 is a communication between Keegan, it's actually a set of communications that ends with Keegan McDonald communicating with Travis Crane, March 17th, 2022, talking about transitional protective yards. This is a set of communications, right? Involving city employees.
Yes.
Mr. Chairman, I'd like to introduce Exhibit 20.
Okay.
I want you to turn to the first communication. So you go to the back of this document. And the first communication in this chain of communications is March 14th, 2022, communication from Jason Meadows, who is the land planner designer associated with the project in question, right, for the developer.
Correct.
Sending a communication to Keegan McDonald and Eric Hodge. You see that?
Yes.
Eric Hodge is who?
Eric Hodge is a planner in the zoning administrator's office.
And Keegan McDonald is also in the zoning administration office.
Yes.
And it appears from this communication that Mr. Meadows is asking for them to give him an interpretation. To provide an answer to a question, right?
Trying to read it.
Well, I'll tell you what, why don't you read it aloud? That'll be fine.
Sorry to continue to bug you, but I wasn't sure if this has been addressed yet. I'm working on a few R4 and R6 compact subdivision townhome projects and wanted to get clarity on the transitional protective yard requirements. If the townhouse lots are all in board, surrounded by the common HOA lot that complies with the district standards for conventional subdivision, are the transitional protective yards required? See attached for an example. Secondly, if they do apply, I assume TCA trumps the transitional protective yard. Please confirm.
So it's fair to say, Daniel, that at this time in March 22, Mr. Meadows is asking the very question that is really at the center of this debate that we have about whether a common open lot, an open area around the perimeter, would suffice as a substitute for a transitional protective yard, right?
Yes.
And so what is the answer? What does Keegan say to him?
Objection, this is in his email, and it's not his call. So, I mean, he can answer, but I'm just pointing out that you just handed him this, and I don't know if he's ever seen it before.
I have not
Well,
seen these emails before.
That's an interesting spin. Most of these documents are not necessarily seen by other sides. We get documents from you that we've never seen. So, anyway, I digress. The email, it's already been part of the record, from Keegan. go ahead and read what he says.
I spoke with staff, and is my understanding the exemption refers to the perimeter residential lots, not the common area lots.
All right, so let's stop right there. So he's saying is that the perimeter lots conventional would be for the perimeter residential lots, not a common area lot. That's what he's saying.
I'd like to not interpret somebody else's emails.
Okay, go on.
In this instance, the dimensional standards for townhouses in R6 are the same whether developed as a conventional or compact development. Assuming those standards are satisfied for all perimeter townhouse lots, then no protective yard is required, though we would need to review the subdivision to make a final determination.
So then later in this email, Keegan McDonald reports to Travis Crane, who would be his supervisor at this time. Yes?
No, Travis Crane is an assistant director. Keegan's supervisor would be Justin Remetta.
In March of 2022?
Yes, I believe so, yes.
Okay. So he's communicating to Travis Crane. Go ahead and read that. That's the first email on the first page.
Okay. Travis, I explained to Jason that the protective yard would be required under today's code as there are no lot dimensional standards for townhouses in R4. However, Missing Middle 2.0 will be establishing lot dimensional standards for townhouses 2-unit maximum in R4. Assuming the perimeter lots meet this standard, then is a protective yard no longer required? See Section 9 of the attached ordinance.
All right. So he is referring to two things. One, explaining to Jason that a protective yard would be required under today's code. That would be with Middle Housing 1 in place. That's what it says, right?
Again, I don't want to interpret somebody else's emails. I wasn't privy to this information, so.
All right. So in terms of getting at the sort of the last thing he says in the first sentence is there's no lot dimensional standards for townhouses in R4. When you deal with let's take a single family detached development. You can do compact development that's single family detached, right?
Yes, you can.
And so you could have more density, meaning you can reduce the lot size, have more single family with part of compact development, right?
Yes.
But as a transitional protective yard, your choice is you do a buffer or you do perimeter conventional lots. And in R4, single family detached conventional lots would be allowed.
Yes.
To be around the perimeter.
Yes.
Essentially, you're creating a fort around the perimeter of conventional looking lots, and that the higher intensity is in the middle, right?
Yes.
And the same would hold true for attached lots. You could do the same thing potentially, is have conventional perimeter lots around the perimeter for attached lots. Those would be bigger lots. In the middle, have a clustering of higher intensity attached dwellings.
That, as well as an open lot. You can have open lot, a series of open lots, as long as it meets the conventional development standards.
Lots is the operative question. Yep, thank you. Let me show you what I marked as appellant 21. Appellant 21 is a communication of city employees dealing with this particular subdivision, isn't it?
Yes.
I'd like to introduce Exhibit 21 into the record.
Okay.
So Exhibit 21 is a communication between John, man, there's some hard names in this city. How do you pronounce his last name?
John Anagnost.
Okay. And who is he with?
John Anagnost.
Can you spell that?
Anagnost.
And what is his job title?
At the time, John was a senior planner.
And in would that be in site planning and subdivision review?
No, John was in comprehensive planning.
Okay. And of course, the email says what it says is that wanting to bring other city officials aware of a scoping meeting involving the subdivision at 908 Williamson Drive. You see that?
Correct, yes.
What is a scoping meeting?
Scoping meeting is basically allows clients to have a discussion with staff to get a high-level review or overview of standards that will be applicable to their scope of work.
And are you in those scoping meetings?
Not anymore, but I used to.
Were you at this time?
Not in this one, no.
Who would be in the who would have been
senior planners, staff.
Okay.
in there.
So give me an example of who would have been in the scoping meeting for this development.
So comprehensive planning, like John Agnost here, he was there. We would have a senior planner from the current planning division. You would have urban forestry, stormwater management, transportation. Pardon me, I'm trying to make sure I don't forget anybody. That's about it.
Who can you still hear me? Who would be there for purposes of dealing with the criteria for a compact development that would be inclusive of this transitional protective yard requirement?
Planning. Current planning would be.
Okay. And
Current planning.
And-
Current planning or land development would
okay.
be.
And so for this meeting, do you recall who was the representative of the city at this meeting, in the scoping meeting?
I do not.
All right, let me show you what I mark as Appellate Exhibit 22. Appellate Exhibit 22 is a chain of communications involving this project, right?
Yes.
Involving the City of Raleigh employees, correct?
Yes.
Mr. Chairman, I'd like to introduce Exhibit 22.
Okay.
This Exhibit 22 includes a communication with that you're involved in directly, right?
Yes.
So, if you can, so you are communicating with Megan Hinkle, and who is she with, or what job is she involved with?
I believe she is in either communications or the city manager's office. Pardon me, I forgot where Megan serves.
Why are you communicating with her at this time?
I think she may have reached out to get some clarification on something dealing with this plan.
So, you're referring to in the second paragraph. You're talking about Germont, and I will contact the applicant. What is the problem here that you're identifying?
I'll just read it because I'm not recalling what the problem was. Jermont and I will contact the applicant to get clarity on the application because it notes single-family units as well as townhome units and attached building type. And a snippet from the application is shown below. Oh, okay. So we were indicating that we wanted to get clarity on the application. They noted several things on the application that we were uncertain of in terms of reviewing their plans. So we wanted to reach out to them and have a conversation about what exactly are they trying to accomplish so we can apply the correct standards to their development.
And specifically that these lots would not be available for single-family dwellings. They would only be available for townhouses, right?
Potentially. But we didn't know, so we were trying to reach out and figure out what was going on.
But at the end of the day, the answer came back that they're townhouses, not single-family dwellings.
Correct.
All right, let me show you what I mark as Appellate Exhibit 23. This is a communication that involves Megan Hinkle, who you had communicated with. Isn't that right?
Yes.
I'd like to introduce Exhibit 22 into the record. Exhibit
23.
23 into the record.
Yes.
So in Exhibit 23, let's just focus mainly on your communication to Megan, which is the following day from Exhibit 22's communication. You, on the following day, have an additional communication with her that, see where it says, based on the feedback we received, staff will be reviewing the townhome building type under UDO Section 2.3.4. This is essentially a compact townhome development in R4 zoning at the moment. Do you see that?
Yes.
And then you go on to talk about Middle Housing 2 ordinance that's in the works, but that won't go into effect until August 8th. Do you see that?
Yes.
And that you note there that the applicant indicated the intent to move forward with a conventional townhouse subdivision in R4 zoning. Do you see that?
Yes.
And then you specifically note to Megan Hinkle the importance, the items of importance. Do you see that?
Yes.
You say items of importance will be a transitional protective yard is no longer required.
Yes, in a conventional development.
Yeah. So obviously, when you say based on the feedback we received, did you have feedback that you received from the developer representatives? Were you part of that group that talked to the developer?
So I think there should be a separation, and there was a scope meeting. I was not a part of that. And then this came later in that we had a conversation with the applicant.
When you say we, that include you?
Me, I believe me, and myself and one of the senior planners.
So let's go back to the question that Mr. Meadows posed to Keegan McDonald in March of 2022. When he asked the question, can I inboard open space and ultimately have this common HOA lot around the border to suffice for a transitional protective yard. Did you talk about that at this time?
Say it again, sorry.
You remember the question that Jason Meadows asked of Keegan in March of 2022,
Yes.
which is the focus of this hearing, the question of can they simply satisfy buffering purposes by having a common area, lot area around the perimeter. Did you have that discussion with the developer representatives here around the time of your Exhibit 23 communication?
Maybe. I can't say for certain.
Well, is there, do you know, did you ever respond to the developers representatives that gave a different answer than what Keegan had given them?
I can't recall.
Okay. Do you recall why you are specifically highlighting the importance of the removal of a transitional protective yard requirement?
No, I can't recall why that was important.
And do you understand that the developer applicant ultimately decided not to go with middle housing 2, right?
I believe so.
And is it one reason is that in conventional development you would have less density than a compact development, right?
Potentially, yes.
Potentially, compact developments you can have more density. That was one of the differences between the two.
Yes.
And so you're allowing the developer to have more density and to satisfy a transition protective yard by what you eventually approved as part of Exhibit 5.
I'm not allowing anything. I am implementing the Unified Development Ordinance. If the ordinance allows a conventional lot or lots around a development, and it meets the standards, we will approve it.
So every time you say or, lot, or lots, I have to point out to you, that's not what the ordinance says.
Understood.
And just to clarify that last point, Daniel, if I'm wrong in that statement, that the ordinance doesn't say what you're saying, that it says perimeter lots, point out in the ordinance where it would be otherwise, and that would match up with something you've been saying. So, at any point in time.
There are several areas in the UDO that will say lot or lots, not specifically in that fashion, but you could understand that when it refers to a lot, it may be multiple lots. Or if it says lots, it may be actually one lot. So, meaning the ordinance says lots, but that doesn't necessarily mean you can apply the standard to, or we will compel an applicant to provide multiple lots.
You have whitewashed the meaning of the plural by saying it can also be singular. You have substituted, what you're telling me is the plural has no meaning.
I am describing how we implement the UDO.
Well, again, going back.
It allows for conventional lots along the perimeter. In this case, they had a conventional lot, and we felt as though it was compliant with the Unified Development Ordinance.
Well, so far in the chain of communication, I'm not seeing anything where you're saying it's good to go so far. Would you agree with that in these communications that we've been going over?
What's good to go?
That what they have proposed and ultimately approved, it was going to work.
It does work because I signed the approval document for it.
I'm talking about the chain of communication so far. They were
Objection to the reference of chain. We don't know what else. We're looking at singular emails. We don't know what all the communications were. He's picked out which ones he wants us to see, but I don't know what the rest say. But
the thing is, when we are citizens and we don't have access to these emails, we turn to the city and through public records ask them to give us the emails. They're the ones that are the custodian of it. I'll be happy to see an email that breaks this up, my chain of emails, to show some different picture than I'm painting. They're the ones that have these documents. We just happen to get them from them.
I understand, and we did a search according to terms. I'm just saying, I don't know what all the communication was. So the characteristic is not necessarily correct, but I'm just trying to get done because we're at 3 hours right now, which was what Mr. Justice represented would be his entire case.
And I will say this, because I know, because I overheard, she said that she's going to object if I take too long. We spent 2 days, I think, talking about standing. Standing was their argument. They're the ones that raised standing. I think we could have gotten through the merits in those 2 days if we just talked about the merits. So I'm trying to move along as fast as I can. Mr. Chairman, with all due apologies to the board, I'm trying my best.
And I didn't say I was going to object. I just wanted to note to the board that we talked about this yesterday and the necessity of trying to get done today and the representations that were made.
I understand. There are a lot of interruptions that occur, but in any event,
I understand. We appreciate everyone moving things along, but we also understand you need to work at a pace that allows you to make your case. So
thank you very
you may
much.
proceed.
Now, because of this, my addled brain is now confused. Did I hand you a document?
Yes, I do.
Exhibit
23.
Okay, and is that a communication involving city employees, including yourself?
Yes, it is. Yes, it is.
I'd like to introduce Exhibit 23 into the record.
We have 23.
Is it 23 or is it 24? Did I mark? See,
It's already,
I have 23.
Mr. Chair, it's already been admitted. I think
I was heading it that direction.
you're backtracked a little bit. You've already gotten it admitted.
There you go. Thanks for keeping me straight, Ben.
So is this one 24?
This should be 24.
Okay.
Is that right?
This is 20, this would be
Yes.
24.
Be sure I handed it to the witness as Exhibit 24.
Yeah,
I
this
think
is the
it's-
Megan Hinkle email from with your name at the top where you printed it Tuesday, July 19, 2022.
No, that's
at 4:19.
yeah. So this is 24.
That's 23.
Yeah, that's 23. So this is 24. Let me remark. Uh-huh. One of the benefits of having co-counsel is trying to keep me straight, but in any event. Sorry about that. Exhibit 24 is what we're looking at. And just be clear, Mr. Chairman, you did allow 24 into the record, right?
Yes, sir.
Thank you. 24 is communication. The next day after July 19th communication, you're sending an email to Justin Romana and Keegan and Eric Hodge talking about these transitional protective yards, right?
Mr. Justice,
Yes.
I don't have a 24.
Well, I didn't mark it. Did I not hand it to you?
I don't think you handed it to me. So the last one I've got was 23, which was.
There you go. Sorry. So your email here of Exhibit 24 is you're saying Jason, that'd be Jason Meadows, right?
Yes.
Is under the impression that neighborhood protected yards are not applicable to a conventional townhome development in R4. Can you confirm this understanding? Correct?
Yes.
And if you go back, through this document, you will see earlier email chains where it's obvious from the email chain that Mr. Meadows is asking about the effect of middle housing 2 and whether or not these neighborhood protective yards are going to be required. It's part of middle housing 2, right?
Yes. Are you talking about March 17th, 2022?
Yeah.
Okay.
But basically, at the end of the day, the developer representative who drew the plans is asking about whether middle housing 2 would eliminate the requirement of the neighborhood protective yard, right?
Yes.
All right, let me show you what I'll mark as appellant Exhibit 25. Exhibit 25 is a plan corrections report that is generated for this project. Is that right?
Yes.
And what is the purpose of the plan corrections report?
That's for, it's a way for us to communicate our requirements and what has not been resolved on the development plan to the applicant, and the applicant can just get a listing of what needs to be corrected.
All right, I'd like to introduce this exhibit.
Okay, accepted. Number 25.
So I'm going to have you turn to page 3 of 5. It's the bottom right-hand corner, and we'll wait till the board passes it out. There's discussion on this document on page 3 of 5 of the transitional protective yard. And the comment says that either a B1 or B2 protective yard or open lot conventional design standards. Do you see that?
Yes, I do.
So this is July 21st, 2022. And in the email communications that we've gone over, and trust me, I pulled the ones that were relevant to the topic. Haven't seen one that changed the opinion that Keegan gave in March that said you had to have a protective yard. So can you tell me, if you know, Daniel, why July 21st there is a comment that says you either do the vegetative buffer or an open lot, one lot?
So that comment would be standard comment in us asking the applicant to demonstrate compliance with the Unified Development Ordinance for this particular subdivision.
So do you have an explanation of, well, first off, who wrote this particular language that we're staring at on page 3 of 5?
So sometimes we have predefined comments, or we have custom comments that we can type up and put in the system. A senior planner would have entered these comments.
Do you know whether it was custom or non-custom?
This is likely custom.
This is a custom where you just hit a document and it prints this out?
Are you asking for the comment or the actual document for corrections?
I'm talking about the comments.
No, so the comment is something we would have likely typed that one up because it's specific to this development plan.
All right. Now it goes on here. The comment is, it would be suggested to provide some type of vegetative buffer outside the TC areas along the perimeter lot lines abutting residential lots to the north and west. Do you see that?
Yes.
The residential lots to the north and west, those are the very folks here that are challenging a decision, right?
Right.
All right, let me show you what I'll mark as Exhibit 26, I think. Exhibit 26 is a communication from Catherine Wilson to Eric Hodge, providing comments and responses. Is that right?
It's odd because this employee wouldn't review subdivisions.
I know it's odd, but it has it is a city employee
It is.
communication.
Yes, it is. Mhm.
All right, I'd like to introduce Exhibit 26 into the record.
Okay.
This communication includes Eric Hodge. You said he's part of zoning administration,
Yes, he is.
so he's in the same department as, or same group as Justin.
Yes. Mhm.
So attached to this email are comments back from the developer to the comments from planning staff, right?
Yes. Yes.
So before we get to the transitional protective yard, on page, if you go into the actual comments themselves, if you go to page 3, it's item 10. There's a specific note there, and we talked about this, is that the code requires for this type of development that notice go out to neighbors within a 100-foot radius, correct?
Correct.
And the response from the developer is acknowledging this, and that does the developer provide these letters to the city, and then the city sends them out?
Correct.
So when in the process is this notification required?
At submittal, but it's sometimes it's hard to do because they need a case number in some instances. If sometimes we get them before they submit their subdivision documents, they'll submit notices before we get the actual plan, and then sometimes they submit them afterwards. So we try to help them in if they come in late, then we try to get them reviewed as soon as possible and mailed out as soon as possible to neighbors, so they are aware of the subdivision as soon as possible.
Well, you have a scoping meeting, and in this case, that took place in April. So you have meetings. In terms of notification, you're saying it's required to be done at submittal, even though submittal here was several months earlier than this?
So scope does not include a submittal. That is just what it is, a scoping meeting where we're just going over a concept plan. When you actually formally submit to the city, that's when you are required to provide notices.
All right. So in response to the transitional protective yard staff comment, and I'm going to read this just for, this is item 21. And again, the note from staff was, per the compact design standards noted in 2.3.1C, a B1 or B2 transitional protective yard or meet the open lot conventional design standards in section 2.2.6. Did I read that right?
Yes.
And then the response is acknowledged. As discussed, the proposed layout does not have perimeter lots directly abutting the boundary of the site. Rather, the common lot abuts all adjoining lots. Therefore, the transitional protective yards are not required. Did I read that right?
Yes, you read it right.
So let's just go back over it. As discussed, the proposed layout does not have perimeter lots directly abutting the, and I'll insert perimeter boundary of the site. It's acknowledging there are no perimeter lots, right?
The developer is saying that.
Yeah. So, again, at that moment in time, when you have an ordinance that's plain and it says vegetative buffer or conventional perimeter lots, and the developer's response is, we're not going to provide the vegetative buffer and we're not going to provide perimeter lots, conventional, why didn't the staff stop at that moment in time and say, this needs to be addressed and fixed?
Because the lot that was proposed met the conventional standard.
In fact, so in the language in question that we've been studying, the developer has substituted in 2.3.1C, has taken the language of type B1 or B2 transitional protective yard or perimeter lots and substituted common HOA lot. Right?
I wouldn't say substitute. He took the option of providing a lot that meets the conventional development option.
Even though at this moment in time, the developer's telling you,
So the developer can say common lot. They can call it something else as long as it meets the standards. Because the developer's not always in tune with the terminology. So for us, yes, it's a common lot, meaning everybody in the development has access to it, or will maybe at some point have ownership of it, but it meets the standard for an open lot in a conventional development option, that's the requirement for a compact subdivision.
you would agree the requirement is either a vegetative buffer or perimeter lots, right?
I would say that the perimeter lots have to meet conventional development standards.
All right, we're at Exhibit 27. Now, it's important to, you would agree that it's important that when you speak to members of the public about how to interpret a code, that you apply that uniformly and equally to everybody, right?
Nope, I don't instruct the public on how to interpret a code. If they're looking to interpret codes or get an interpretation, they would have to speak to the zoning administrator's office.
I'm sorry, I may have used the wrong word, interpret. When you are in a meeting and you're telling a developer one way of doing things, and another developer comes in and wants to do the same thing, you would expect that you would tell that developer the same thing.
We provide them the code sections, and they attempt to demonstrate compliance with it.
This Exhibit 27 is a communication from you to Justin Ramada relating to a Barnwell Road townhome development in R4 compact development. Yes?
Yes.
I would like to introduce this exhibit into the record, Mr. Chairman.
Yes, sir.
So you are, Daniel, so in your communication to Justin, it looks like Jermont Purifoy is asking about a different development and the issue about a protective yard. Isn't that right?
Yes.
And just read what you said to Justin. Good afternoon. Jermont is, go ahead and read that.
Jermont is reviewing a compact townhome development in R4. UDO Section 2.3.1 requires conventional townhouse lots in R4 for perimeter lots when opting out of a protective yard. Would staff apply the 2-unit living standard as well? We are asking if the townhome lots have to be, pardon my grammar here, have to meet conventional standards, but does that requirement impact the building type where only 2-unit living is permitted from conventional townhomes in R4? I'd appreciate any insight.
So when you are sending this email that says the perimeter lots have to be conventional townhouse lots in R4 when opting out of a protective yard, what do you mean by that?
Mr. Chair, if I could just, again, object to relevance, this is a plan that was reviewed under Missing Middle 2.0, not Missing Middle 1.0.
The reality of all this is we're talking about protective yards across the board. So this is just this is occurring around the same time as the other development in question. I'm just asking for the distinction. So what do you mean by this?
I believe we were trying to determine what building type or what lot would be, what would be permissible as a perimeter lot in this development.
This developer, Barnwell, was not putting in a protective yard, right?
I don't know.
Let me show you what I mark as appellant exhibit 28. So exhibit 28 is a compilation of plan review comments for a townhome subdivision known as Barwell Road, that's Barwell Road Townhomes. Is that right?
It appears to be.
I'd like to introduce this into the record, Mr. Chairman.
Okay.
So I would like for you to go to the beginning of this, or maybe it's the end. So you turn to the very first, turn to the back. It's like the width discussion. Go to the back, and if you look at the highlighted section, there's, this is a proposed townhome development, R4, correct?
I believe so.
And the comments from staff at this time to this developer is that a transitional protective yard is required. You see that?
Yes.
Now that is different than what you eventually told the developer of the challenge project here on Williamson, right?
The comments are different.
Well, the comments, of course, are different. In fact, the staffer is pointing out you have a note that no transitional yard is required. And so the developer had noted on the set of plans no protective yard is required for a townhome development in R4, and your response is it is required.
It's not my response, so we would have a senior planner doing a review of these plans and answer the
I
comments.
apologize. Someone under you is
Okay.
making this comment.
Yes.
Can you tell me the difference why there would be different, you said language, different comment language. Why different approach here of saying for one developer, compact development, or for eventually they can ignore the protective yard. This developer is told you can't ignore the protective yard. Do you have an explanation for it?
If I had time to review this in detail, I could probably have an explanation for it.
Well, obviously, there'll be a
But-
break, and then they'll more than likely want to ask you questions, so you'll have more time to look at this, Daniel.
Okay.
Thankfully, probably you think is thankfully, I'll have just three documents left.
Okay. Okay.
And Mr. Justice, I was just going to actually ask, given the time, if you have a sense, I don't want to break your rhythm, but if you have a sense of how much time you need versus the comfort of all of us to take a lunch break.
I'm fine taking a lunch break. I can sleep standing up if I'm forced to. I'm very flexible. I was the fourth child, and by that time, no one gave me anything. So I'm good.
Is this a good time for everyone else if we take a break?
How much longer did you say you have on direct?
So I have three documents here. Hold on one second. So with this witness, I would think that 10 minutes.
We're good to finish the direct before lunch.
Well, if it can, I don't want to push you, but if it can be wrapped up that quickly, I think it'd suit us all to go ahead and wrap it up and then take our break at that time.
That's fine.
Everyone can hold on. All right, thank you.
All right, let me show you what I'll mark as a. Yes, I'm just making sure I get it the right order. Appellate Exhibit 29. This is communication from you to Justin Ramada dealing with the 908 Williamson Drive project, correct?
Justice.
Dan, you're the fourth child.
It's real short. Can't see me.
This is communication that you authored, right?
Yes, sir.
I'd like to tender this exhibit as part of the record.
Okay.
So Exhibit 29 is a communication from you to Justin Ramada and Jermont Purifoy. Is that right?
Yes, sir.
And you're just noting to Jermont, you say, looks as though Jason Meadows resubmitted plans for that controversial development on Williamson Drive. Let's get eyes on basically it as early as possible, right?
Yes.
If you go back and you look at the comments, developer comments were part of Exhibit 26. There is a, and I'm looking under Jermont Purifoy's comment, so that's in this exhibit, it's 1, 2, 3 pages in. It's 2 pages into the comments themselves. Do you see item 2 under Jermont Purifoy's comments, where the question's being asked of the developer, do you want to apply missing housing to, or stick with the rules that we have in place? Do you see that?
Which exhibit?
This is exhibit number 26.
26. Okay. That was line 2. Thanks.
Under Jermont's comments. Do you see the question or the comment that's posed about whether they want to use middle housing to text amendments?
Yes, I do.
And they're basically saying that we're good with the rules that we have, right?
Yes.
And of course, if they can get in a compact development more density with this quote-unquote perimeter lot, that it makes sense, doesn't it? They would stick with what they had. Is that fair to say?
Sure.
All right, let me show you what our mark is, Appellant Exhibit 30. Exhibit 30 is a communication that involves you, right?
Yes.
I'd like to introduce Exhibit 30 into the record.
Yes, sir. So you're in this communication, Exhibit 30. Jermont is pointing out that the neighborhood notification letters were just sent in. This is September 14th, 2022. And then it goes on to talk about the lack of screening or buffering along the perimeter being the biggest complaint so far from neighbors. Do you see that?
Yes, I do.
And then he does settle down on his point of, well, how can we regulate this under our code? Right?
Yes.
All right, let me show you what I've marked as Appellant Exhibit 31. Exhibit 31 is communication from you to Justin the very next day, right? Justin Ramada, the very next day is a communication from you, right?
I don't know about it being the next
Well, maybe
day.
not the next
Yeah, I
day,
got
but
you.
within a week. So
me.
following up on Exhibit 30 is a communication from you.
Yes.
I'd like to introduce Exhibit 31 into the record.
Okay.
So Daniel, in this, so just a few days after Jermont is pointing out the concern of neighbors, you are asking Justin Ramato the very question about, in his opinion, of whether common lot 18 suffices for opting out of a transitional protective yard.
Yes.
So if this thing, this topic, this question has been supposedly around, long-standing topic or question, why are you asking the question again September 20th of 2022?
Because if we weren't unclear, then we would reach out to the zoning administrator's office.
So if it was unclear, you would reach out to the zoning administrator's office?
Yes, on how we need to implement the code.
So the point of that is, was it apparently made clear by a long-standing line of construction prior to this time, or you wouldn't have been asking the question, right?
Well, each plan is unique, and so we try to implement the standards and take into account that particular plan.
Do you understand what I'm asking you? Is you are asking the very question that this board is being asked to address, which is whether or not this lot, open area lot, suffices for a transitional protective yard, meaning that a developer can opt out, just as you say.
I'm not asking if the lot suffices a transitional protective yard.
Oh, so I'd like to get your opinion on the perimeter lot. If common lot 18 meets conventional standards, can the site opt out of a transitional protective yard?
Yes.
I apologize if I misstated my previous question, but you're asking the question that is the focus of this challenge is, does common lot 18, as drawn by the developer, suffice for purposes of opting out of a transitional protective yard? You're asking that.
Yes.
And I didn't see a communication after this.
Okay.
So did you get a written communication after this?
I cannot recall.
Well, do you recall what the answer was?
I recall that we have approved this development because it meets the standards.
And you recall who saying that to you?
No, because we have an approval document that I've signed that indicates that this development it complies with the Unified Development Ordinance.
That's an implication that in December you sign a document where you sign off and saying it's approved. I'm saying in response to your question, September 20th, 2022, what was the answer and who gave you the answer?
I cannot recall what the answer was. I just cannot recall what the answer was. I do know that we approved the development.
All right, let me show you what I'll mark as Exhibit 32, and this is the last communication I have. This is a communication involving city employees dealing with the project in question, correct?
It involves city employees. I'm not certain if it involves the development in question.
Well, right down below it talks about the townhomes proposed for Williamson Drive. You see that in the email right at the bottom of the page?
Yes, I see it.
Okay. I'd like to introduce this as being record.
Okay. It's number 32, right?
So this is an email communication from Patrick Young to Keegan McDonald, Justin Ramada, and Travis Crane, dealing with messaging as it relates to this Williamson Drive project. Right?
Yes.
Patrick Young is who?
He's our director.
Planning director.
Yes.
So Patrick Young gives a response to a Hal Jones, whose letter is attached, noting the concerns about the proposed development at 908 Williamson Drive. Do you see that attached? Hal Jones's letter of September 7th?
Yes.
And so, in a nutshell, the City of Raleigh Planning Department, in messaging about this particular project, is talking about the benefits of providing housing and making more opportunities available for affordable housing, right?
Yes.
When you were when you were implementing the development application, the one in question, did you have any conversations with folks like Patrick Young or from the city manager's office? That would be Megan, right? So you did.
If she works in the city manager's office.
Well, did you have meetings with the mayor?
No.
Did you have meetings with the planning director?
No.
Did you have meetings with Megan?
No, I did not.
You had communications, though.
Yeah, this email, that's it.
Okay. Why do you have any idea why it's necessary to send out messaging about this particular controversial development? Do you have an opinion either way?
I have no opinion.
Mr. Chairman, if you give me a moment, I think I'm almost done. So we talked about the fact that you had Barwell townhouse development around the same time in R4. There was another development in R4 called Laurel Hills, right?
I recall Laurel Hills, yes.
Y'all approved that development plan, right, for the townhouse development?
Yes, we did.
It was a compact development in R4.
I believe so.
And Laurel Hills is around the same time as the Williamson Drive project, right?
Maybe.
Well, let me show you what I've marked as Appellant Exhibit 33. Exhibit 33 is a copy of the development plan the City of Raleigh approved for the Laurel Hills compact townhome development in R4, right?
Yes.
I'd like to introduce this exhibit in the record.
Okay.
in a nutshell, Daniel, this development, compact development R4, you see on there is a transitional buffer yard provided.
Yes.
Can you tell me anything that would distinguish why the developer of Laurel Hills put in the transitional protective yard versus the developer of Williamson Drive who did not, when you're dealing with a compact development in R4, 4 townhouses at around the same time?
I can't recall.
Those are the questions I have, Mr. Chairman. That's all I have of this
Okay,
witness.
I'm sorry, I couldn't hear that. Thank you.
I'm sorry.
Oh, very much appreciate that. Okay, in a full morning, thank you very much for everyone's patience. Mr. Birch, is there something you wish to offer?
Yeah, I was going to ask the board or ask Craig if we could get a projection for how much his case in chief is going to take. We're at 3 hours and 45 minutes already. And, you know, again, we had a goal of getting this done today this is our 3rd day. Combined, direct, and cross on both standing and case in chief. Craig's gone about 11 and a half hours. We've gone about 3.5 hours. And, you know, we just want to get a sense of, you know, can we finish this up today?
I always get this in trials where the opposing side tells the judge of how long I'm taking. And at the end of the day, I don't, Mr. Chairman, I should never tell anybody time. I try to move as fast as I can. I have one more witness. And, you know, I can break this up in terms of 11 hours Craig and 3 hours us. We had standing arguments because the city raised the argument. We didn't want that argument. They raised the argument. That's why we took 2 days dealing with that one thing. So we could have got through this without that motion, but here we are. Today's the first day of the merits, and so I've taken up the morning, and now I want one more witness.
Okay. Well, we don't know a time on that. We have an answer, one more witness, and then we'll move on to the city's side of the conversation. It's 12:15. I think we need to break for lunch. Is 45 minutes sufficient for everyone so we can?
Yeah.
Okay, excellent. Let's be back at 1 o'clock then and reconvene at that time. Thank you very much. reconvene. Mr. Justice, I understood you were through with Mr. Stigall at this point?
Yes, that is correct.
I'm sorry, sir.
Okay. Ms. Tatum, do you wish to cross-examine Mr. Stigall?
Yes, please.
Invite him back up then.
I'm going to try to keep what I'm talking about on the screen. So, the board. Good afternoon, Daniel.
Good afternoon.
I just have a couple of questions. You were testifying earlier, you were the person who had the final sign-off on the subdivision plat that's on appeal, correct?
Correct.
Okay, and that subdivision requested townhouse lots in the R4 district, correct?
Yes, correct.
Okay, and townhouse lots are allowed in the R4 district under the compact option, correct?
Correct.
Okay, and that the density for those types of lots was increased by the city council when they passed missing middle 1.0, is that correct?
Correct.
Okay. Now, that was a decision of the city council, correct?
Correct, it was.
That you administer the UDO that they pass every day that you're basically working?
Correct.
Okay. So what I've put on the screen is from the, that was from the, is this not from the record? This is it's part of Craig's supplement number 19. And you see it's section 2.1.2 called housing options.
Yes.
Okay, and section B, what is that entitled?
Compact development option.
Okay, and can you basically read that provision about what compact option is?
Yes, for UDO section 2.1.2, housing options, subsection B, a compact development permits a reduction in lot size for residential subdivisions in exchange for an increase in common open space. This allows for efficient residential subdivisions and ample amenity area for the residents. Open space thresholds are district-based and are listed in UDO section 2.3.1. For projects under these minimum open space thresholds, only the conventional option can be used. Applicants that choose the compact development option must set aside 20% of the total project area or the minimum district-based requirements, whichever is greater, as common open space. Requirements for the configuration, use, and management of common open space are set forth in Article 2.5.
Okay, and that is the provision that was enacted by the city council, is that correct?
Yes.
And it says that compact development is basically you get more density in exchange for open space, correct?
That's correct.
There is no reference whatsoever to any kind of buffers or transitional protective yards being a part of that that decision.
Correct.
Okay, I'm also putting up now section 6.2 of the UDO, which is also the supplement 19. Now that provision, says residential uses, household living, and what is subsection G?
Compact development.
And how is that defined?
Compact development is defined as a compact development permits a reduction in lot size for residential subdivisions in exchange for an increase in common open space. This allows for efficient residential subdivisions and ample amenity area for the residents.
Okay, there's no mention there of any part of compact development, the purpose of it being to have any additional buffers or transitional protective yards, is there?
No, there's no provisions for that in this section.
It's just a switch, density for open space, is that correct? So when a compact development comes in, you basically go to section 2.3.1. Is that correct?
Yes.
Advance to the next slide. Oh, there it is. Okay. And is that the provision that we've been talking about today?
Yes.
And when we were looking at section 2.1.2, the housing options, when you were reading the compact development options, it said that you would go to this section right here to determine the rules for compact development. Is that correct?
That's correct.
Okay. And so we're in the R4 district. That's correct?
That's correct.
So the first thing I want you to look at is subsection D, which is residential unit types. Now, in R4, how much of the site in R4 can be dedicated to townhouse development?
100%.
Okay, so you can use the whole parcel.
That's correct.
Okay, so the other requirements, there's several other requirements. So this is what the city council says we go to determine whether a compact development is allowed. Correct?
Correct.
Okay, there's something called site density. Is there any site density in subsection 4?
In subsection?
R4.
No.
Okay, and then the next part is open space.
Correct.
And for R4, it's 20% or 1 acre, whichever is greater.
Correct.
Okay, if you could, let's go to slide number 6 here. Sorry. Oh, there it is. Okay. Is this the site data that appears on the first page of the approved subdivision plan?
Yes.
Okay, and if you look at that, can you tell me what the open space requirement is?
Yes, 1 acre minimum, 60% minimum, if you're looking at the percentage.
Okay, and how much did they provide?
They provided 65%. Well, essentially, 1 acre.
Okay, 1.009 acres.
Yes.
And of the total acreage is the site area?
Yes. Total acreage is 2.423 acres.
And is that about roughly 40% of the entire site?
Yes.
Which is dedicated to open space?
Yes.
Which, according to the UDO, it's the higher density, but almost half of the site is open space.
Open space, yes.
Okay. So the amount of open space has been met.
Yes.
Okay. So if you look at the plan, I'm not sure if you can read it on there. You can make it bigger? Will it help if you make it bigger? Can you see where the open space is on that plan?
I believe it's in the top right-hand corner, listed. Oh, you're talking about on the plan, sorry.
Yeah.
Thought you were talking about the
Is there a
line.
little bit in each one of those areas?
Yes, there is.
So can you kind of point to the areas where the open space is?
Yes, so there's some open space here around the, which it also encompasses the TCA, and then in the middle of the lot, and then up to the northeast corner.
Okay, and the UDO section 2.3.1 says that it has to be at least 50 feet. So, in this area, in the first area you looked at over here,
Yes.
is there at least a 50 by 50 foot area in that area?
Yes, there is.
So once that's established, does it matter? I mean, once you have 50 by 50, it's met. Is that correct?
Correct, yes.
It is, the requirement is met. What about the second open space area?
In the middle here, yes. There's at least a 50 foot by 50 foot block of open space in the middle.
So that's been met. What about
Yes.
the third one?
Correct, yes. There's a 50 foot by 50 foot block here.
Okay, so with respect to section 2.3.1, can you find that again? The open space area on this plat is at least 1 acre, and every open space area is at least 50 by 50.
Yes.
Okay, and that is what the city council has decided is required for townhouse subdivision in R4. No more
Compact.
open space requirements, that's it.
That's it.
Okay. So the next section has been much talked about, is transitional protective yard. And that is the title of that section, correct?
That's correct.
Okay, and then that's the title, but then the text goes on to explain what that means for purposes of this section, correct?
Yes.
Okay, and we've been talking about this, and you can read along. It says, for purposes of a compact subdivision in R4, that you would do a type B1 or B2 transitional protective yard, or perimeter lots must meet the dimensional standards of Article 2.2. Is that correct?
That's correct.
And it has been your testimony that there are 3 options there. Is that
Yes,
right?
Yes.
And any of those 3 options meet subsection C, which is entitled transitional protective yard.
Yes.
Okay. And regardless of whether it's one lot or multiple lots, let me ask you this. Could a townhouse subdivision have more than one perimeter lot?
Yes.
So it could have one or more,
Yes.
but any lot that is a perimeter lot has to meet the requirements that are in subsection C.
Yes. Article 2.2, conventional development option.
Okay, so there are several options in 2.2 for conventional lots. Is that correct?
That's correct.
And this particular one, I think, is slide 15. If you could go to slide 15. You don't see the numbers on there anymore. It's the open lot one. Yes, right there. Okay, that's section 2.4.7. Is that right?
Yes.
Oh, one more. Sorry, one more. Nope. What did I do? Okay, that's conservation. Okay, hold on. There we go. Section 2.2.6, conventional development option. Okay, why would you use an open lot standard here?
Why would they use an open lot standard here?
Yeah, is it because there's nothing on the lot?
Correct.
Yeah, so this is the standard that was used in determining whether or not that 2.3.1C, the perimeter lot size was met, or the requirements, correct?
That's correct.
Okay, and if you look at R4, the dimensional requirements are found where?
226A.
Okay, so those are the requirements for purposes of this section, perimeter lots for a compact subdivision. Those are the requirements right there. Under
Yes.
R4, what is the requirement?
So under R4, that perimeter lot would have to be a minimum of 10,000 square feet in area, and then the width would be measured, would have to be 65 feet wide for
Okay.
that lot.
Does building coverage matter?
Not at this point, no.
Okay. So if you look at, and I'll bring you one of these. If you go to the subdivision plat, CE1, right here. I can find it for the board. Can you look and see what lot 18, what the area is? It's right. It's right here. What is the area of that open space lot?
So lot 18 is 72,649 square feet, which is 1.668 acres.
Okay, and the requirement under the code is 20,000 square feet,
Yes.
or 10,000.
I think it's 10,000.
Okay, so that requirement has been met.
Yes.
And that's a requirement of the city council, correct, that they enacted in the UDO?
Yes.
Is that ambiguous to you at all?
No.
Okay. So the next thing is the lot width. And I think you testified earlier how lot width was met.
That's correct.
Okay, and Mr. Justice has handed you a page of the, no, was it an exhibit? Yeah, part of Exhibit 4, which is Article 1.5. Does that tell you how to measure lot width?
Yes, it does. 1.5.1C lot width.
Okay, and what does that say?
Says lot width is the distance between the side lot lines, generally running perpendicular to a street, measured at the primary street property line along a straight line or along the chord of the property line. A lot must meet the minimum lot width for the entire minimum required depth of the parcel except for cul-de-sac lots.
Okay, and what I've put on the screen is what's been identified as LA-1, which is a landscape plan on the approved plat. Can you see where the lot width appears there?
Yes.
And what is that lot width?
The lot width is 321.6 feet at Williamson Drive.
Okay, so that clearly meets the requirement of lot width under 2.3.1, which is 65 feet, correct?
Yes.
Now, if you look, is the lot width of Iredale shown on there?
Yes. Yes, it is.
And what is that lot width?
The lot width at Airedale is 271.5 feet.
So that would be met on, if that was the primary street, assuming it was, that lot width would be met there, correct?
Correct.
And why do we do lot width at this particular stage of the approvals?
Because when we have a dimensional standard that requires a minimum lot width, we have to measure that with the preliminary subdivision. Because
Okay.
at this level, we're concerned with the lots.
So that was the reason that the primary street was selected, is so you could find the lot width,
Correct.
to find out if the lot width met the compact subdivision requirements, correct?
Yes.
But they would be met regardless of the primary street. Is
Yes,
that
in either
correct?
direction, yes.
Sorry, if you guys could take a breath between each speaker, please. You're starting to overlap a little
Okay.
bit. It makes
Okay.
it hard for me to get everything. Thank you.
So regardless of the primary street, it could be Iredale or Williamson,
Lot width would still be met.
the lot width would still be met. Okay, so if we go back to section 2.3.1, if you can help me out there. Again, this is the UDO requirements for this subdivision. So we've been through open space and determined that it's over an acre and it's over 50 feet in all directions. There's 3 sections that are 50 by 50. So,
That's correct. So,
yeah.
yes.
So that's what you would have looked at when you're checking
Yes.
to see. And then when you look at the transitional protective yard, you are looking at the third option, because it says B1 or B2 or perimeter lots. You check that perimeter lot, and you determined that it met the size and all of the requirements for an open lot, correct?
Yes, it met the lot width and it met the lot area requirement.
As a matter of fact, it's pretty much well in excess of the requirement, isn't it?
Yes, it is.
Okay. So again, in your opinion, based on the you administering these UDO provisions, which were enacted by the city council, you found that this proposed subdivision met the UDO requirements.
Yes, that's correct.
Okay. Now, when you're making that decision, you don't decide whether it's a good idea or a bad idea to have a bigger buffer or a smaller buffer, do you?
No.
You just look right at the unambiguous provisions of the code, correct?
Yes.
Okay. So you have had your position, you said, for 1 year.
Yes, I have.
And during that 1 year, you've been signing off on preliminary subdivision plats, correct?
Yes, preliminary
Okay.
subdivision plans, yes.
Do you remember every single plat you signed off on?
No, I don't.
No, you don't. There's no way you could keep up with them, is there?
No, there isn't.
Okay. So as opposed to only during that year that you were signing off on them, the subdivisions that were approved between 2013 and when you started your position in 2022, you don't have any personal knowledge of what subdivisions, compact or otherwise, were approved, do you?
No, not without researching.
Not without researching. Okay. So you've said on a couple of occasions that if there is a desire for an interpretation of the zoning provisions in the UDO, that decision is made by Justin Remetta. Is
That's
that correct?
That's correct.
And is that because he's the zoning administrator?
Yes.
So is it fair to say that he is the final call on any interpretations of the UDO provisions?
Yes, he is.
So if there are emails between individual staff members or conversations, those are not the final determination until Justin Remetta says it is. Is that correct?
That's correct.
Okay. One last thing. I'm going to hand you here. This is the Board of Adjustment record page 0225. Mr. Justice had brought it up here. It's not on there. On a poster board. 1.4.2 building types allowed by district.
Yes.
And I don't know if Craig, can I use your?
It's in here.
Okay, and I think we said that this was the version that was in effect when the application was filed. Can you even hold it? I mean, you can look at it. Do you know whether this is still the version that's in effect or not?
No.
Okay, but with respect to this, Mr. Justice had asked you to read, if you look here, it says townhouse residential, there's a box and a 1, correct?
That's correct.
Okay. And he asked you to read the 1.
Yes, he did.
And the 1 said that townhouses and apartments are allowed as part of an approved development in the TOD overlay, and that's correct,
That's
right?
correct. That's what it says.
What he didn't ask you to do is read the box. What does the box say?
Building type allowed as part of an approved compact conservation or cottage court development.
Okay, so under this particular chart, you can do townhouses under either option, right?
That's correct.
They're not mutually exclusive of each other.
No.
Okay, thank you. Just give me 1 second, and I think I'm going to turn it over to Mr. Birch.
Thank you. Mr. Stegall, if you could, we can get section 2.3.1 back up there. That is the compact development standards. Yep, I'll do a better job. So under that subsection C, if you could, explain to me the options for complying with section 2.3.1C.
So in this section, with regards to the site boundary of a development and a compact subdivision, the developer would have an option of choosing a type B1 or type B2 transitional protective yard, or perimeter lots that would meet the conventional development option in Article 2.2.
Thank you. And so in that section that you just read, after it says type B1 or B2 transitional protective yard, it gives a code reference. Is that correct?
Yes, it does.
And that, what is that a reference to?
That's our transitional protective yard, section 7.2.4.
Right. And so that section is what kind of governs what is allowed, not allowed in a transitional protective yard. Is that correct?
Yes, it does. Yes.
Now, the other option aside from providing a type B1 or B2, is a perimeter lot. Is that correct?
That's correct.
Now, the code does not require or doesn't dictate what type of perimeter lot is provided. Is that correct?
Correct.
And there is no prohibition on a developer choosing an open lot so long as it meets the open lot standards.
In conventional development, yes.
Yep, in the conventional development. Thank you. And just to clarify, a perimeter lot is not considered a type of protective yard, correct?
That's correct.
So a perimeter lot, because it's not a protective yard, it does not have to comply with the protective yard standards.
That's correct.
So it does not have to be landscaped,
No, it does not.
and vehicular surface area can be allowed on a perimeter lot.
Yes.
And the option of choosing type B1, B2, or perimeter lot, is that an option kind of at the developer applicant's election? The city doesn't dictate that, correct?
That's correct.
I think that's it.
I had one more other thing I just remembered. With respect to that open lot standard, in R4, it's 10,000 square feet in area and 65 feet in width. And those are the only two requirements for that lot, correct?
Yes.
So there's nothing in the code that prohibits it, that requires it be in any certain shape, correct?
That's correct.
So when Mr. Justice showed you how this lot is configured on the site, that is perfectly legal under the UDO, correct?
That's correct.
Because you're just looking at area and width.
Yes.
Okay. You're good? We don't have anything further.
Okay, thank you. Before we redirect, board members, do you have any questions? Okay, Mr. Justice, you wish to redirect?
Yes, please. If you would, well, you said you've been land development manager for approximately 1 year, but you've been a city employee going back to 2016, right?
That's correct.
And in fact, you were a planner, a part of site plan, subdivision plan department, right?
That's correct.
Reviewing site plans, reviewing subdivision plans, that's what you did as a planner.
That's correct.
And so I understand that as a supervisor, you've been doing it a year, but you've been doing it looking at site plans and subdivision plans for 7 years.
That's correct.
And again, as we sit here today, you can't identify one project where you allowed a developer to do exactly what you're allowing this developer to
That's
do with the
correct.
transitional protective yard.
That's correct.
Now, since we were talking about the open lot, can we pull up section 2.2.6 on the big screen?
Keep your microphone handy.
Is that conventional?
Yes.
Conventional. All right. So that depicts what an open lot would generally look like, right?
Yes.
The streets, the roads, are not part of an open lot, according to that diagram.
Right, but you could have a private drive or an alley.
Well,
Open lot.
let's jump ahead to configuration of open space in 2.5.3. And while we're doing that, you've already said that for purposes of that, and I called it garbage open area, but for purposes of that area that's north of the tree conservation area, the area around the perimeter, the area that is the main focus of what we're talking about, that area is not hatched for a reason, because it doesn't qualify as open space under the code. Right?
It could qualify as open space.
I'm sorry, you had hatched everything on the plan that qualified as open space. You are now reversing that and saying, well, they could have and should have hatched everything around there, including the road?
They met the requirement, and if they want to go and add additional to it above that, they could do that as well.
At the end of the day, it's not hatched as open space, is it?
That's fine. No, it's not.
And if you go to section 2.5.3, dealing with open space,
That's not in this PowerPoint. 2.5.3, you said?
yes. I'm sorry, are we going to get to it on the screen or do we not?
That's all code, Daniel.
So in terms of common open space requirements, Article 2.5 sets out standards for an area in order to qualify as common open space, right?
Yes.
Section 2.5.3A says the minimum width of the space is 50 feet. Yes?
Yes.
I think it's your interpretation that means that there can be open space that would qualify that would be less than 50 feet in width.
No.
Okay. So you do understand that in order to be open space, that open space has to be 50 feet in width.
That's correct.
Now, in terms of allowable uses, if you turn to section 2.5.4, it lists allowable uses of the open space.
That's correct.
And then if you jumped over to, and in here is alleys or streets, is that allowed use?
I don't see that.
You jump over to section 2.5.6, prohibited uses, open space. Item
That's right.
C specifically says streets and impervious parking area.
That's correct.
So the road that's identified on the plat and the parking area is identified on the plat, that's not really a allowed use within area deemed to be open space, right?
That's correct.
So if you can pull up the section 2.1.2 housing options that you were asked on cross.
Does I need to go back to the PowerPoint? Or?
Are we there?
You said 212, correct?
Yeah, it was something that Robin had just was asking about at the beginning of your cross. 2.1.2.
Yes.
All right, housing options. And I think she said this is what the city council adopted, and then she had you read compact development option.
Yes.
All right. So in that compact development option discussion, is there specific criteria for setbacks for compact development?
No.
Is there specific standards for, is there specific standards at all that are mentioned in that general explanation? Specific standards?
No. This is just a description.
Yeah, and so, granted, transitional protective yards is not mentioned there, but you would have to agree that the specific standards for compact development, despite what this general language would say, that you still have to meet section C of 2.3.1, right?
Yes.
Since we were talking about the plain language of section 2.3.1 that says, or, the vegetative buffer or perimeter lots, have you, since the break, have you found any provision of the code, the UDO, or anything that would inform you as to the meaning of perimeter lots in a way that would suggest that that is singular tense and can be a singular lot? Do you have anything else you can point to in the code?
I did not research during the break.
Those are the questions I have.
Thank you. Thank you. Ms. Tatum, Mr. Birch, any follow-up?
I have a couple. You want to go first? Okay, just a couple of things. Mr. Justice asked you if you were a plan reviewer for years before you were a supervisor, is that correct?
That's correct.
And you said yes. Were there other reviewers too?
Yes, yes.
Since 2013, when did you say you got here,
2016,
16?
December
So
2016.
from 2016 to 2022, there were multiple reviewers, correct?
Yes.
And you didn't review any at all between 2013 and when you got here?
No,
So there's a lot of plats out there that you don't know about, is that correct?
that's correct.
Okay. So let's go back to, okay, the subdivision plat, CE 20. Now, Mr. Justice has his exhibit, which shows exactly where this open space lot was, okay? And he has what he's called garbage space on there, okay? But the fact that you have an open lot of a certain acreage, do you have to fill every bit of it with something?
No, you don't.
Okay, so this is just part of the open lot that is not already open space or some other thing.
Right, right.
And so the road is not in the open space, correct?
That's correct. So, pardon me, Robin, just in this area, if you can you see my cursor, sir? So in this area here, we wouldn't count the roadway as part of any open space. The open space is already met up here. However, he's correct in that there's a small sliver of property back here that's very thin. However, you potentially, if it meets all the criteria for open space, you could count this area back here, but it have to be part of the review. But they've met the requirement in this section up here and the other two areas.
So they can leave that with nothing on it, that's fine, right?
That's correct.
Okay, and they can put the road in the open lot, and it's not in the open space, correct?
That's correct.
So Mr. Justice was kind of mixing up open lot and open space.
Yes,
is
and
that
that's what I really hope you all don't get confused on is there's a requirement for open lots and there's a requirement for open space. They're totally separate standards.
And part of the open lot contains the open space, correct?
That's correct.
But there's part of the open lot that doesn't have open space.
Yes, that's
Nor does
correct.
it need to,
Correct.
okay? All right. All right,
Just a moment. We're a technical issue, just a moment.
that's okay, that'll help me get to the right slide. This is 12.
All right.
I don't know how you get the numbers on here. Let's go to 12. There we go.
Okay, need a reboot. Go ahead. Anyone needs to stand, now's the time. Confirm, Ms. Tatum, you said you and Mr. Birch are through with this? I'm sorry, we're back on record, yes. Get you, once you're ready.
Yes, we are finished.
Yeah, sorry. Okay, you want to confirm you're now through with, okay, Mr. Justice, anything further with this witness? Thank you. Appreciate your time, Mr. Gall. Okay, Mr. Justice, I think it's back to you for another witness.
Yes, calling back Jeffrey Brown.
Okay.
Jeffrey Brown. Jeffrey, you're still under oath. And just a reminder to the board, he was tendered as an expert in civil engineering. His written statement is in the record as Appellant Exhibit 3. And I'm going to try to, if I can, expedite things. So Jeffrey, your affidavit and report identifies your opinion of areas where the city committed an error in its review and decision related to this 908 Williamson project, right?
That's, excuse me, that's correct.
And one of the main areas that you dispute in terms of their determination is what we've been talking about for almost the whole day, the transitional yard requirement in order to be a compact development. Is that right?
That's correct, yes, sir.
So why don't you walk through the board, your analysis, if you will, using the report to walk through your analysis.
All right. We have talked about this a lot, or I've listened to a lot of discussion about this, so I almost apologize that we're going through it again. But however, based on my experience, as a design engineer, consultant, and a consultant who has worked with and on behalf of towns and municipalities across the state, and having read several different entities, UDOs, that's how my approach here, just a little more background. So the plans were, again, that I reviewed were submitted as a compact development, and we get to the section 2.3.1, which I think we've seen several times. Can we put that up, or do we have it right there? Okay, thank you. Yes, we've seen this several times today, I'm sure. And again, we're in the R4, and let's get straight to the point on the transitional protective yard, and which would become applicable to this project. You can have a type B1 or B2 protective yard, which in effect is a landscape buffer, which is very common in UDOs I have reviewed.
And so just again,
Yes, sir.
a little bit cutting to the chase, there is no B1 or B2 vegetative buffer that's part of these plans.
There is not, no, sir.
And just tracking this along in your report, this discussion that you're going over and sort of summarizing can be found starting on page 3 of your actual report. Mr. Chairman, members of the board, just to track along.
That's correct, yes, sir. Page 3 of, if you still have my report. The key to this would be, again, in my experience with UDOs and the interpretation thereof and the intent, they are very language specific. And so, whereas this says you don't have you can have this B1, B2 protective yard to meet the transitional yard. This other option of the Article 2.2 conventional development option, my experience has been that when this type of language is used, that means it needs to be used for a transitional protective yard. It's very common when you look at development that's in infill work, especially infill in residential communities. If the conversation was about industrial or commercial, these protective yard questions can be different. But this is very appropriate conversation that I'm used to reading in terms of protective yards in residential communities, specifically older communities with infill. So underneath that that history there, if you would, in my opinion, in my experience, is that, you know, we don't have the transitional yard, and we clearly don't have the alternative, which is in Article 2.2, which if we need to pull that back again to read it, do I need to read that for you?
No, but at the end of the day, just if you have do you have your affidavit in front of you?
I do.
Yeah, just track through the second point that you're making.
Okay.
Do you see multiple perimeter lots around this perimeter?
There are no conventional lots around the perimeter.
All right, continue on.
Okay. And I mean, that's the statement.
And have you sort of diagrammed what would be illustrative of perimeter lots being plural? Have you laid this out on this site?
I laid out on this site a conventional detached exhibit. And I did not lay out if you could do the perimeter lots for a conventional site with this particular layout, because it just gets incredibly tight, if you would.
You have laid out an actual buffer,
G.2.
right?
I have. It's in G.2, what I laid out for you. Let me turn to it. I apologize here. So in G.2, I laid out a conventional plan, just the entire site development. And then what I laid out, and I did add what I laid out in G.2. It's at page 2. I didn't do an exterior loading plan. I laid that out as if you had the B2 buffer, the 20-foot buffer.
And so when you lay out on the exhibit in G2, page 2, Mr. Chairman, do you see that page?
Just getting to it. Actually, no, I'm not.
Okay, it's the page right before Exhibit G3. It's the last page as part of Exhibit G2.
Is this G as in George? Is that-
George, yes.
Okay, thank you, I found it.
All right, so if, by laying out a vegetative buffer on this site, how would that affect the Fairview Farm Circle Road and the townhouse lots?
So the point of this exercise is to see what the effect would be, particularly on the 17 townhouses as proposed. And as you can see, what happens is the internal road pulls more internal, if you would, and you lose approximately seven parcels internal to that. So you're down to about 10 townhomes. That effectively, that do meet then that 2.3.1C transitional yard.
So it is your opinion then that in terms of the section C that deals with that's titled transitional protective yard, there are no vegetative buffers, and there's not more than one conventional lot around the perimeter.
That is correct.
And at the end of the day, to install a buffer as required, that would dramatically impact the density of this location.
It does, yes, sir.
And you were saying that if you had the site is so small in acreage that if you had to lay out perimeter lots that met the 10,000 square foot standard for minimum lot size, that would effectively eliminate this as a townhouse project.
That's correct, yes, sir.
So in terms of other areas where you believe the city erred, you have a discussion here of the primary streets designation. And as you know, in this, one of the determination they made was the primary street was Williams instead of Iredale. Can you walk through with the board your analysis about that, and why do you believe the city erred, and ultimately why it matters?
Well, the process was to look at this type of infill projects that do have multiple street frontages, which will trigger the application of what is section 1.5.4.c, which is the determination of the methodology for determination of which street is the primary street of which your setbacks are ultimately determined from. And I did two things. The first of which was go through the UDO and determine that since the block face of both Williamson and Iredale drives are not predominantly developed with townhouses as proposed, then that section 1.5.4C.2 did not apply.
So can we stop right there?
Certainly.
And ask if the city would put on the screen section 1.5.4C? And
Yes, sir.
for purposes of your written report and statement, this the analysis that you're discussing is found on page 2 of the report, right?
That's correct, yes, sir.
So you testified that ultimately this section drives what a building setback would have to be for this development, right?
That's correct, yes, sir.
And you were walking through why this section 1.5.4C2 leads you to believing that Iredale is the primary street. So go on, if you will.
I will. So as I move further along, the appropriate item is 1.5.4C.3, which says for an attached or detached building, a corner lot shall designate its primary street as being the opposite the rear yard of any adjoining lot. If the corner lot abuts only the side yard of adjoining lots or abuts another corner lot, then the primary street shall be located along the narrowest street frontage. If the two street fronts are within 10% of each other's lengths, either street may be designated as primary. So if you look at the GIS map, the lot line opposite Iredale, the back lot line has a rear lot line. So I chose, it met that piece of the UDO, so I chose Iredale as the primary. The important piece of that was the second item I did. I sent my licensed surveyor to survey all the setbacks within the required frontage on Iredale, and I arrived at a setback, the median setback, as being 25 feet.
And you didn't get into that ultimately a primary street designation can correlate to what's considered infill compatibility, so that if there's a historic neighborhood, that you measure sort of the historic setbacks there and try to match it up to the new development, right?
That's correct. And so if we refer back then to the second exhibit in G.2 there, I then applied the 25-foot front setback to the project.
And if you're applying a 25-foot setback, how would that affect any of the lots that were approved?
It potentially takes the lot on the eastern north side out in potentially the southwestern cornermost lot, townhouse lot.
And you have a map that you've drawn depicting this?
I do. It's in the G.2. We just had it open. I want to get back to it to make sure that I stated that clear enough to the board here. G3, there it is. Yes, it has more of an impact on the townhouse lot, which would be on the eastern side of their development. It has a very small impact on which would be the southernmost lot on their development. But you'd have to do some shifting around of the existing footprints.
So let's move back on to stormwater, which you cover in your report. Can you talk about this swale versus ridge conversation and give the board some further insight on that, please?
I can. I believe I had a good conversation with the engineer, and he pointed out correctly what his attempt to doing in creating not a swale but a ridge line. It doesn't change my opinion. The swale just diverts water off the back of his retaining wall. There's still a section of water that flows down and then flows onto the Bennett. So my opinion hasn't changed in terms of stormwater still leaves the site onto the adjoining parcel.
Those are the questions I have, Mr. Chairman.
Thank you. Ms. Tatum?
Okay, sorry. Yeah, just a couple of things. First of all, we talked yesterday, and you said you've never done any work in the city of Raleigh as any development work, represented any property owner at all to get development approval under the Raleigh UDO, correct?
That's correct. Yes, ma'am.
Okay, so your first experience with the Raleigh UDO has been in this case, is that correct?
That's correct. Yes, ma'am.
Okay, and you were hired by the appellants to support their contention that the UDO requirements were not met, correct?
I was hired by the Van Winkle Law Firm
What was your charge?
to do a review of the plans, the project documents, the Raleigh UDO, as if I were doing a review based off my experience, as if I do for the city of Brevard now, currently.
Okay, but you knew that the case was a challenge to the approval, and you were representing the parties who claimed noncompliance. Is that correct?
I did my review prior to reading of the affidavits.
Okay, so you weren't told what side you represented?
Well, I knew that we were representing to landowners, yes, ma'am, but I did not read the affidavits prior to my review.
Okay. All right, what do the affidavits have to do with anything?
The affidavits from the homeowners?
Yes, what do they have anything to do with whether or not the UDO was complied with?
I think the affidavits speak for themselves. They were talking about what they felt their impact would be.
Okay, and they are lay people that feel their impact. They're not engineers, are they?
I'm not aware what they do for a living, no, ma'am.
So are you saying you based your opinion on whether the UDO had been complied with the affidavits of the homeowners?
I did not say that, no, ma'am.
Okay. So I do want to put in for the record an objection to those affidavits that the same way we did yesterday. We just found them last night and found out there was another affidavit from one of the appellants who did not testify. So for purposes of the truth of the matter, we'll lodge that same objection as yesterday.
Noted.
Okay. So let's go to section 2.3. Can you help me? Okay. Okay. And you just rendered an opinion. You were talking about section C, transitional protective yard, correct?
I did, yes, ma'am.
And you said that, in your opinion, a B1 or B2 transitional protective yard is required, correct?
That's not my opinion. That's the statement of fact, what the document says.
Okay, but it's required. You have no option to do a perimeter lot. Is that your testimony?
That was not my testimony, no, ma'am.
Okay. How is it required pursuant to this section?
Well, let's read it. It says a type B1 or B2 transitional protective yard or perimeter lots must meet the dimensional standards of Article 2.2, conventional development option of the district where the property is located.
Well, let's go back. It says type B1 or B2 transitional protective yard or perimeter lots must meet the transition. There are two options. There's an or there, isn't there, in between the transitional protective yard and the perimeter lot?
There are three alternatives to meet a transitional protective yard. Yes, ma'am.
Okay. So there are three options to meet subsection C, which is entitled transitional protective yard. Is that correct?
There are three alternatives to meet the transitional protective yard requirement. Yes, ma'am.
And one of those is to have a perimeter lot or lots that meet the dimensional standards of Article 2.2.
I'll go ahead and interject since they did it with me. It says perimeter lots. I think she just said lot or lots. It doesn't actually say
I'll
that.
get to that, Craig.
Well,
All right.
it's my objection.
Okay, that's fine. But a perimeter lots, if you want to say, someone could do perimeter lots according to your argument. That's not our argument, but that is an option. You do not have to do a type B1 or type B2. Is that correct?
Can you please rephrase that question? You put a lot
Yes.
into the front end
Type
of that.
B1 or B2 is not required if you meet the third option relating to perimeter lots.
There are three alternatives, type B1 or B2, or perimeter lots that would meet the transitional protection yard requirement. Yes, ma'am.
And if the perimeter lot, I will say lot, you can say lots, I'll get to that in a minute, they only have to comply with Article 2.2 conventional development option, the dimensional standards. That's the requirement, correct?
Perimeter lots must meet the dimensional standards of Article 2.2 conventional development option
Okay.
of the district where the property is located. Yes, ma'am.
Okay, and have you looked at those requirements?
I have, yes, ma'am.
Okay, and that requires a certain lot width and a certain lot area. Is that correct?
If you'd like to pull that up, I'd be happy to look at it with you.
Okay. It's the open lot one. Open lot. 2.2.6.
Okay. Thank you.
Okay, and in R4, it has to be a 10,000 area lot area, correct?
The minimum area is 10,000 square feet per lot. Yes, ma'am.
Yes, and this perimeter lot has more than 10,000 square feet, doesn't it?
Are you referring to lot 18 as a whole?
Yes.
Then lot 18 as a whole has more than 10,000 square feet. Yes, ma'am.
Okay, and the lot width is greater than 65 feet, correct?
Are you referring to lot 18?
Yes.
No.
Okay, have you looked at the slide that sets forth the lot width as being 361 feet?
That's just at the road. Yes, ma'am.
Okay, have you reviewed the UDO provision that explains how you determine lot width?
I've heard it spoken several times and I've seen it. Yes, ma'am.
Okay, so it says it's the distance between the side lot lines measured at the primary street line along a straight line or the chord across the property. So tell me where you would measure. Oh, this is not PowerPoint. Which one it is? That one. Okay, right here, if you can see can you see the lot width line? Have you looked at this before, the lot width line, 361 feet?
That's a road frontage line, yes, ma'am. I see that as a distance, yes.
Are you saying that it does not comply, it does not comply with the UDO lot width provision?
I'm saying that I've never, I would take, based upon my experience, and I would suggest any type of real definition of lot width here, that if you want to say the lot is 365 feet wide at the front, but then you're going to have to say it's 5 feet wide in the rear. And the problem with that is that makes no sense at all.
Okay, so even though the UDO tells us how to measure it, you say that's not a good way, so we should use something else?
I think the UDO is, I think the UDO is very clear when it says it needs to have B1, B2, or multiple lots. I don't see where it says, I really don't see where it says that you can have a lot width of 300 feet that reduces to effectively, if you wanted to, an inch. That flies in the face of any type of standard I've ever seen, quite honestly.
Okay, except the UDO, which happens to measure lot width.
But I
that
don't
way.
believe the UDO says that.
Okay, so we understand. The UDO measures lot width in one way, but you have never seen it like that before. Is that correct?
Well, the reality is you get UDOs that will say this. That's very common. And it's common throughout your UDO, particularly on these open space numbers. It gives a square footage in a minimum width of 65 feet. Right out of the gate, if you just do basic math, that gives you a depth of what that lot needs to be just to meet a standard amount of square feet. It doesn't say that I can gerrymander and finagle around a piece of property. It doesn't say that.
Well, it doesn't say you can't, does it?
It says that you need to have a B1 and B2 or lots for a transitional protective yard.
Okay, that's not the question. The question was, did it meet the two requirements, lot area and lot width? This particular lot.
Well, that's kind of a tough question because when I reviewed this, it was very somewhat unusual. I do a lot of infill, and I know in infill projects, they will go in, account, I'm going to give them open space. And because it's so small, I've got to tuck my stormwater in there. And then, I got to have my tree space area. And then I need to have an amenity. And I need to do all, and that's what they've done. And then somehow, at the end, they've smashed it all into one extra lot. So there's at least 5 or 6 different components to this one lot. So when you start talking about lot width, I go, well,
I guess you tell me,
you're using
why
it for
doesn't
open
it mean
space, but open space, but you've got utilities and.
I just have to say, what's going in right now, because I'm not going to keep doing what I'm doing. I'm going to put a parenthetical that says simultaneous speakers, and then I'll just pick right back up, which means I am going to miss some of what's said, because I cannot take down 2 people at the same time. I only have one mouth.
Understood. Thank you.
Okay, let's just go to this contention that you say it's got to have a B1 or B2 or lots, and that the lot width requirement is something other than the UDO. Okay, so you say that it has to be more than one lot based on subsection C, correct?
I don't say that. Again, the UDO says that it has to be a B1, B2, or perimeter lots.
Okay, let's just look at that language real quick, though. Okay, that section is entitled Transitional Protective Yard, correct?
Section C is, yes, ma'am.
Yes, that section does not govern in any way how many lots can be in a subdivision or on a subdivision plat, does it?
Well, I would suggest the only thing that governs truly the number of lots is how much land area you have. But this clearly just states multiple. lots. It's
Right,
plural.
but it says perimeter lots must meet. Now, doesn't that mean that's applicable to any development in the city, correct? This isn't limiting it to one particular plan, is it?
No, it doesn't say, we're in Article 2.3 under compact development. That's
Right.
not citywide.
Well, what I'm saying is, it says that perimeter lots must meet the dimensional standards. Doesn't that mean to you that means any perimeter lot or lots that are in the compact development, in a compact development, regardless of how many perimeter lots that there are?
I'll be honest, that question didn't make much sense to me. Can you
Okay,
please
so you're just saying you can't have one, correct? You say you cannot have one, you must have two. Is that right?
No, ma'am, that's not what I said.
Okay, what are you saying? You keep saying there's an S on there, and that's real significant. So I'm trying to figure out why.
It's plural, yes, ma'am.
Okay, and what is that? So that means you're fine if that perimeter lot was 2 lots, they'd be in compliance if both of those lots met the requirements of an open lot?
I believe that it states they have to meet the requirements of Article 2.2, conventional development option. The lots would, yes, ma'am.
Okay. Do you know if the current perimeter lot could be divided into 2 and each one of them would meet the open lot standard? Do you know whether you could make 2 of them?
I do not have that answer for you, no, ma'am.
Okay. Well, assuming for purposes of argument that you could turn that perimeter lot into 2 and both met the requirements, would you then agree that even under your theory, the transitional protective yard section would be met because there was more than one perimeter lot that met the section?
Well, I'd first like to say that it's not my theory. I'm just reading your UDO. So, and it says B1 or B2 and the multiple lots. So,
Go ahead. I understand that, but we have a different interpretation of the word lots. Have you reviewed the UDO in its entirety and seen how many different ways the word lot and lots are used?
I've reviewed several UDOs, probably more than I can count on both my hands. And UDOs, while they're not perfect in language, however, they strive to be specific for this very reason. That's what I have found through my experience.
Okay, but this UDO, you haven't studied how the word lot or lots is used, correct?
I have not done a Boolean search to find every word lot or lots in this UDO, no, ma'am.
Isn't a potential interpretation that the words perimeter lots could mean that any perimeter lots that use the compact development option, whether there be one or more?
Please rephrase that question.
What I'm saying is that this section applies to any compact development in the city of Raleigh, correct?
I believe 2.3 applies to compact development. Yes,
Okay.
ma'am.
Okay. So if you were to go to the transitional protective yard section, then and read that, it says that any kind of perimeter lots must meet the dimensional section. Couldn't that mean it could be one lot or multiple lots depending on the development?
I believe it says what it says, and that or perimeter lots.
Okay, I understand. So you're saying that this transitional protective yard section is the determining factor on how many lots that you must have in a compact development for a perimeter lot?
I never said that.
Well, you're saying that you've got to have more than one because it says lots.
I did say that
Okay.
because that's what this thing says, your UDO.
Okay.
But I didn't say that it would determine the number of lots. That is totally site dependent.
So but just 2. You say 2 is the number, at least 2. That's your position.
Well, plural. So plural is generally 2 or more. Yes, ma'am.
Okay. All right. You also testified that the reason that you believe this primary street determination is important is because it's determined for setbacks. Is that correct?
That's what the UDO says. Yes, ma'am.
Okay, are you aware that in the city of Raleigh, the setbacks are not reviewed or determined until a building permit application is submitted?
I'm aware. I learned a lot the past couple of days, but the point of my exercise was to do an overlay on the property to show the impact.
Okay, but this subdivision plat doesn't have any buildings, so there's no setbacks that are relevant at this time. Is that
Well,
correct?
the plan, excuse me, the existing plan shows setbacks, so someone's done the exercise of looking at it. Yes, ma'am.
No, the plat itself, the approved plat does not have setbacks on it. The approved plan.
I believe the plan that I reviewed in one of the plan sets shows a 10-foot building setback on it.
Where is that? Yeah. But on the subdivision plat itself, there's a setback on there?
It's right there. It's hatched. It's a hatched setback on the front and both side lines of the property.
Okay, that's not a building setback, though. It is? Yes. Okay. Could that setback, but for purposes of when you put them on the ground is when you determine what the setback is that correct?
It's been my experience throughout multiple municipalities. The reason why it's shown here is that someone has reviewed it for compliance. Otherwise, what if a building lot is in the setback? In this stage, you're approving a plat, which is a lot. And if
Go ahead. Is it a subdivision plat requirement to put a setback on there? Or is it just being on there for informational purposes?
I believe that setbacks could be used for multiple purposes, and through construction, through platting, through dedications, you see them on several different applications. Yes, ma'am.
Okay, could the setbacks change between the time that the plat is approved and the building permit is submitted?
I think that would be project dependent.
But this is based on infill requirements, correct? You've been looking at the infill requirements.
I guess you'd have to show me a specific example of why the need for a setback would want to be changed.
Okay, but the setbacks that are in effect at the time the building permit is submitted is the ones that will apply, correct?
That also can change. There's a lot of variables in there. It's a hard question to answer.
Okay. Do you know whether the primary street always remains the same, or could that potentially change after the buildings were constructed?
Through my experience, I have not seen a primary street change once it's been allocated. No, ma'am.
But you don't know whether in the city of Raleigh that could happen?
It's been my experience that I've not seen the primary street change in the municipalities that I've worked in. No, ma'am.
Great, Mr. Chair, thanks. So, Mr. Brown, if you could, if we can get the UDO.
Mr. Birch speaking.
Yep.
Mr. Birch is speaking.
Yep. Sorry about that. I'll
I
stand
should
up.
have said something. I'm sorry.
I'll stand
We made
up.
eye contact.
Yeah. If we could get Article, actually, we'll start with this section of infill. If we can go to Article 2.27, or 227, residential infill compatibility.
Thank you.
And Mr. Brown, you see the subsection B, applicability?
I do, yes, sir.
If you could read that, just the first sentence under that, next to that numeral 1.
The standards contained within this section apply to any buildings in an R4, R6, or R10 district where all of the following are present.
Great. And you can stop there. We don't need to read the A, B, C, D. I just wanted to note that it says it applies to any building, right? It doesn't say that it applies to a lot. Am I correct in reading that?
The standards contained within this section apply to any building. Yes, sir.
Okay, thanks. Next, if we could go to Article 1.4.1. Great. And so, Mr. Brown, on your report, I guess page 2, under the section primary street designation and residential infill compatibility, in that paragraph, the last one on the page that starts with, in moving further into the UDO, there you seem to say that a townhouse is by definition a form of an attached building. Is that correct? That's what your report says?
Which sentence are you reading, just to be clear?
Yep.
Are you referring to my sentence, since the infill project does not consist of apartment, general, or mixed use or civic building?
No, it's in that last paragraph, in moving further into the UDO.
Okay, yes.
You seem to say that the proposed buildings, part of the subdivision plan, even though we don't have building, but the proposed buildings are an attached building?
Townhouse is a townhouse. It can be an attached building, yes, sir. None of the other parameters fit. That was the one that would work for an attached townhouse.
So tell me where you see that a townhouse can be an attached building.
It is by definition. You can have, just walk down the street in downtown Raleigh, look at all the townhouses, they're all attached.
Right. So since we've been focusing on words matter, let's go to kind of the section that is driving this conversation, which I believe is in 227. Sorry. Justin, I'm sorry. If you can go to I guess we're in the primary street determination. So that's 154C3. Right. So in this section 1.5.4C, we are following certain rules to determine a primary street, correct?
Yeah, in 1.5.4, as a whole, we're looking for building setbacks, and under item C is the multiple street frontage lots. Yes, sir.
Great, thank you. And under that, we see the following rules determine a primary street, and then we have 1 through 6 on this page, and then there's a few others. But in your report, you kind of go through 1 and 2. So you acknowledge that subsection 1 doesn't apply because a townhouse building is not an apartment, general, mixed use, or civic building, correct?
That's correct, yes, sir.
Okay. And then subsection C2, you say doesn't apply because it's not developed primarily with townhouse building types, correct?
I believe it does not apply. I stated, yes, they're not predominantly developed with townhouse building type.
Right. So then the first part of subsection C3, it says for an attached or detached building, right? And the words attached and detached, both of those words are capitalized, correct?
That's correct, yes, sir.
So we'll assume those are defined terms. So now Justin, if we could go to the allowable building type page, which I believe is 1.4.1. And here you see the different building types that are permitted in the city. And you see that an attached house is a different building type than a townhouse. Is that correct?
In this 1.41, they have different definitions. Yes, sir.
That's right. And so, and as we go into each of the subsections in Article 2 and Article 3, for all the different development options, and we can go to each of those pages, but there are different standards applicable to an attached house as compared to a townhouse, right? They are treated separately, correct?
That's correct. Yes, sir.
Okay. So, when the prior section that we were looking at, that subsection C3, said for an attached house or detached house, that didn't list townhouse, correct?
Let's go back to that section again, please.
What section, Michael?
That is 1.5.4 C3. Says for an attached or detached building, right? In that subsection C3.
Yes, sir.
So it does not list a townhouse building in that subsection C3, correct?
That's correct. But if just to clarify here, this is talking about the neighborhood, not the development. So if you look,
we'll stop you there. It's not. It's talking about the things being proposed. This applies when you have a development plan for a particular proposal, and this subsection C3 says when you are proposing an attached or detached building type. It doesn't say when you are applying a plan for a townhouse building type. Right. Again, we'll just stop there. I think we have what we need on that section. So, yeah, okay. I know that Robin spent some time with you on lot width. So, I think you said in your experience, UDOs, when they're regulating lot dimensions, will often include we mentioned lot width. Sometimes there's lot size. Maybe we can go to section 2.3. Let's go to section 2.3, even for just a detached house. That's great. So here in the lot dimensions, right, there appears to be, I'm looking in 2.3.2a, lot dimensions. There appears to be a lot area, a lot width, and a lot depth. Is that correct?
that's correct. Yes, sir.
Okay. And then, sorry, Justin, I know I keep getting you up and down, but if we could go to the lot width part, which is, I believe, 1.5. It's the lot standards. Great. There, lot width, which is 1.5.2C. And so it says lot width, Robin already covered this, lot width is the distance between the side lot lines measured at the primary street, right? If you could read that next sentence. A lot must meet
A lot must meet the minimum lot width for the entire minimum required depth of the parcel, except for cul-de-sacs.
Right. So we were getting into like what the shape could or could not be of the open lot. We were talking about, well, where do we have to meet the width? Right? And so here it says, well, we have to meet the width at the primary street, correct?
That would be correct, yes, sir.
And then it's got to meet that width for the minimum depth, if there is one, correct? Isn't that what that second sentence says?
It says it was required to meet the depth, it must meet the minimum lot width for the entire minimum required depth of the parcel.
Yep, for the required depth, right? So now let's go to the lot standard for an open lot in a compact subdivision.
Compact or conventional?
Do what? That's right. Sorry, conventional. Thank you. So we're in section 2.2.6. This is the open lot for a conventional subdivision. So let's go to the lot dimensions.
I'm here, thank you.
Yeah. So we've got a minimum lot area, correct, for R4, 10,000 square feet.
That's correct, yes, sir.
And then we have that minimum width, right, of 65 feet.
That's correct, yes, sir.
But there's no required depth there. Is that correct?
The depth would be,
No, I'm sorry. I'm asking you, is there a lot depth? Remember how there was a lot depth
there's
listed?
no depth listed here, but
Right.
in order to maintain 10,000 square feet with 65-foot width, you're going to have a minimum depth.
Well, you'll have a depth. It's not a minimum depth.
No, you would have a minimum depth. That's just math. Divide 10,000 by 65, and that's your minimum depth.
No.
Yes.
All right, let's go back to the detached lot. Conventional's fine.
Okay.
All right, detached house. Lot area, R4, 10,000 square feet, right? Lot width, 65 feet, minimum. Depth, 100. What's 65 times 100?
So in this particular,
I'm really just asking. What is-
6,500, but
Right,
but
and
to
so-
answer your question, I think I can opine as an
I'm not-
expert, and I'd like to finish my
Not over
answer.
one another, please.
Mr. Sir, I'm just asking you questions right now.
Well, I
And
understand, Michael,
Craig-
but you understand the problem, and I just compounded it by talking over you, that you've got to let the witness finish, and then you can jump on them. So please let my witness finish.
Yeah, Mr. Birch, you at least allow, I understand the point you're making, but allow him to finish.
Go ahead, Mr. Brown.
So I understand your point. When you multiply a minimum by a minimum in this table, you don't reach the minimum area. That allows the developer, through his engineers and surveyors, to then adjust either the width or the depth of the parcel to meet the 10,000.
Right. And just so we're completely clear and we're looking at the same thing, I see a minimum lot depth listed there, correct?
That's correct, yes, sir.
So let's go back to 2.2.6, open lot. Just so I don't see a lot depth minimum there listed under 2.2.6A. Do you see a line item that says lot depth minimum?
I do not see a depth minimum because it's been my experience that what this is doing the same thing the other table does. When you put a 10,000 square foot area and they're telling you, we're only going to give you one minimum here, so that's no longer adjustable. You've got the adjustable bit is going to be the depth.
So you mentioned in your experience, and I believe you already told the board, that experience does not include any experience in the city of Raleigh with this UDO?
It does not, no, sir.
And you'll acknowledge that the UDO for certain building types, like a detached building, under lot dimensions includes a minimum depth, but an open lot does not include a minimum depth, at least just in the chart. We're both looking at the same thing. The charts do not provide a minimum depth for open lot, even though it does for a detached building, correct?
So you made a lot of statements in there you'd like me to agree to, so I'm just going to state here that this 2.2.6 does not have a minimum depth on it.
Great, thank you. Great. Mr. Chair, finished. Thank you.
Okay, thank you, Mr. Birch. Sir?
Thank you, Mr. Chairman. You keep being asked these questions about Raleigh specific. If there's not a definition in the code, like for the term lots, then you understand you apply sort of the common ordinary meaning of lots, right?
That's correct, yes, sir.
And what the common ordinary meaning means for citizens of North Carolina is that the common ordinary meaning for folks in Murphy of lots, if it's not defined otherwise, common ordinary meaning in Murphy would be the same common ordinary meaning in Manteo. And since Raleigh falls right in the middle of all that, the common ordinary meaning of lots would be the same. Yes?
Yes, sir.
And so, although you're not experienced with Raleigh, when you looked at this code and in the absence of a definition, you applied your experiences to come up with a common sense meaning of terms, right?
That's correct, yes, sir.
Now, if we could go, and Michael admitted that words matter, so if we could pull up section 1.5.4C. In that, on the right-hand side, where the focus was in number 3 for an attached or detached building. Do you see that?
I do, yes, sir.
Now, that terminology of attached or detached building, you remember he then took you over to the table and pointed out an attached house, right?
That's correct, yes, sir.
Did he point you to a table that identified attached buildings? Because house is a different term than building, right?
It could be, yes, sir.
And a townhouse, I think your opinion is a townhouse is an example of an attached building, right?
That's correct, yes, sir.
So if they had wanted to limit this to for an attached or detached, if they wanted to be specific to duplexes, they would have used the term houses for an attached or detached house, because that's the terminology used elsewhere, right?
That's correct.
And you keep it being, you were asked, and other witnesses were asked, that all this doesn't matter because ultimately there's no buildings. Exhibit 26 is in front of you, I think, which is, Mr. Chairman, this was the comments from staff and the responses from the developer. Do you have that in front of you?
I do. I believe it's an email from Catherine Wilson.
Yeah, with these comments between staff and the developer for this project. If you turn to page 2
Okay.
Of the comments, there's a section that's labeled number 1 that deals with the question of what is the primary street.
Okay.
See that?
I do.
It starts out with, this is under Germont Purifoy.
Okay. Yes, sir. I see it now. Yes, sir.
So the staff is directing that as a component of this compact development, that all the parties need to decide what is the primary street, right?
Correct, yes,
And
sir.
that as part of this development approval, the city made a determination of what is the primary street.
They did, yes, sir.
And that if we did not appeal that determination within the appropriate time, that determination would be binding upon us. Is that your understanding?
That's my understanding, yes, sir.
And so if later, when a building is put on the lot, the primary street determination's already been made, right?
That's correct, yes, sir.
And the primary street determination drives what the building setbacks will be, right?
That's correct, yes, sir.
So you were here when there was a sort of a discussion and information through Daniel of sort of history of compact subdivision standards and conservation standards. You were here in the room for that, right?
I was, yes, sir.
And this section that is most relevant section dealing with transitional protective yards. Those standards are applicable to compact developments and conservation developments, right?
That's correct, yes, sir.
And so up until Middle Housing 1, you had the conservation developments had to be a minimum of 12 acres in R4, right?
That's what I heard, yes, sir.
And that for compact developments, they had to have a minimum acreage of 8 acres before Middle Housing 1 took effect, right?
That's what I understand, yes, sir.
So when you deal with such a large piece of property, and 8 acres and 12 acres, you would agree, is not infill.
No.
And so on those larger tracts, it would be looking at the transitional protective yard options. There are 3. You would agree, would you not, that the developer certainly has a lot more flexibility in either on such large acreage putting in a B1 or B2 buffer, yes?
That's correct, yes, sir.
Or laying out conventional lots that are of like kind and similar to the adjoining neighbor's lot, right?
That's correct, yes, sir.
So that the higher intensity uses and denseness that is driven by compact development are taking place in the middle and surrounded by conventional lots, right?
Yes, sir.
And it's really, I made the comment before, it's like a fort of either a buffer or similar lots around the perimeter for the neighborhood, and in the middle is something more dense that apparently anybody buying in there, whoever's buying those conventional lots, they'll just have to deal with being adjacent to more dense lots. Is that a fair commentary?
That's a fair commentary, yes, sir.
So when did you see anything when the standards changed where the 8 acres went away from compact and the 12 acres went away? Have you seen anything? You've been here the whole time, right?
I have, yes, sir.
Have you seen anything that would suggest that the idea of protecting the neighbors, either through buffering, vegetative, or having like-kind lots, i.e. the objective of transitional protective yard, that somehow that was changed? Did you witness anything while you've been here?
I did not. It seemed very consistent to me that the transitional yard has been preserved.
And so, and your testimony is that if they were going to lay out like-kind lots around the perimeter of this 2 acres, there's really not enough room to then do that nugget of dense townhouses, right?
That would be my opinion. It's an awful small parcel, yes, sir.
And so really, the option 3 is not really an option to honor the integrity of a transitional protective yard. It should have happened with some buffering, vegetative in this case, right?
Yes, sir. That's the exercise that I went through.
And the exercise you went through, if the developer had honored the integrity of this separation with buffering, that would have wiped out
at least 7 of the townhouse units?
Yes, sir, at least 7.
Okay. Now, Robin was asking you over and over again about the meaning of perimeter lots, and you mentioned, she was saying, well, lot or lots, it could be both. And I just want to turn you back to Exhibit 26. As you know, as you just went over this. This is the, and you have this. If you look in the developer's own words on item 21 under Jermont Purifoy, it says in the developer's response, the proposed layout does not have perimeter lots. Right?
Correct. Do I need to read that to you, or?
That's what it says.
It says that, yes, sir.
Those are all the questions I have, Mr. Chairman.
Thank you. Ms. Tatum, Mr. Birch, anything?
I'll just real quick, on section 2.3.1, it's getting kind of confusing here. Just one question. We're back to the section C, and what you just said is that if you utilize the third option, perimeter lots, it would not honor the integrity of the section. Am I correct? Is that was your testimony?
I don't believe I said that, no, ma'am.
Okay. Isn't it true that a perimeter lot is an option, perimeter lots under your theory, if there were 2 compliant perimeter lots, that it would comply with subsection C?
I haven't been able to see 2 perimeter lots to be able to review and answer that question appropriately.
Okay. But assuming they met all the requirements, 2 would do it, right?
Again, it's a small lot. The configuration of that lot with between roads, utilities, stormwater, then you put all those components together and present lots, then I could be able to review it. Yes, ma'am.
Okay. So you're not going to, you won't concede that if there were 2 compliant, it would comply with this section?
I think I'm trying to answer the question is that it's a complicated question because there's multiple variables to which you can't make a general statement that, oh yeah, that's great or not great.
Okay.
I just am saying that given the variables, and given the variables, then if they present a multi-lot configuration, I could certainly review it and then probably be able to answer your question.
Okay. Take this plan out of the mix. Doesn't that section give an option that does not require a type B1 or type B2 if that third option is complied with?
Again, the transitional protective yard does state that a type B1 or B2 transitional protective yard or perimeter lots must meet the dimensional standards of Article 2.2 conventional development option. Yes, ma'am.
Okay. I don't have anything else, Michael. Okay. We're finished.
Thank you. Mr. Justice?
No, sir.
Okay,
Thank
Mr. Brown, thank you very much.
Thank you
Appreciate
very
your
much.
time. Mr. Justice, it's 3 o'clock. Could we take a short break?
Please.
And will you have anyone else to call when we come back?
No, sir.
You're okay. Excellent. Thank you. Let's take 10 minutes, and we come back. We'll give the city, we'll have the opportunity to present their information. It occurs to me that I did not give, yes, ma'am. It did not occur to me that it occurred to me that I did not give our board members opportunities to ask Mr. Brown any questions. So let me just see, does anyone here have questions for Mr. Brown before we move along? Okay, thank you. Seeing none, we'll now move to Ms. Tatum for the city's presentation.
Thank you, Chair Swink. We just wanted to, before we get started, maybe talk about scheduling and timing. I think it's become apparent to us that we're not going to finish today. We both have witnesses that will take, as longer than, not as long as Daniel Stegall, but I do not think that we can get through even one of our main witnesses before 5 or 6 o'clock. So what we don't want to do is start a witness and then stop that witness and go away for a couple of months. We don't think that's fair to anybody. So what we would propose, we do have one witness that we think we can do fairly quickly, is to call that witness and then to save Justin Remetta and the engineer for when we come back so we don't have to break up their testimony into 2 different dates.
That certainly makes sense in terms of our time, Mr. Justice.
So to understand, you want to present the shorter amount of time witness today, and then we reconvene at a date certain that we determine today.
Well, if we can determine a day, I don't know if we can or we can't, but we don't want to, if we've got a 4-hour witness that we're not going to get through, we don't want to start them. So that's what we want to do, the shorter witness and do a time certain.
Yeah, no, I there's no problem with that. So the one shorter witness today, and then we agree to get together before several months are away. We get together as soon as we can.
Okay, and if we can maybe spend the time after this witness, maybe checking calendars and things like that.
Sure.
And maybe I can get Lou in here.
And there's also we can do like we did the last time. There's a July 10th meeting of the board.
Yes.
We can try in the meantime to figure out a date in August or whenever the earliest date that we can all get together.
Yeah.
And then at the July 10th meeting, they could do the same thing that they did
Okay.
in
Well-
June. So the easy answer at the end of this meeting would be to continue it to that date for that decision like we did before.
Well, maybe. It took a lot of time and effort and hours and weeks to figure these dates out. So to the extent we can narrow it down, I would appreciate it. And I
Let's
know
do
Mr.
that at the
Birchwood-
end of the meeting, and let's, I think in the interest of time, go ahead with your first witness, and I appreciate your thinking that through.
So, Mr. Chairman, just to alert that, I do have co-counsel. Obviously, I would like for him to be present.
Absolutely
So,
understand.
and he's not here. He's
Understand that.
finishing up his treatment and doctor direction.
Sure.
So we would have to figure out ultimate schedule a little bit later, but we'll commit to get it done as soon as we can.
Right, and just talk generally afterwards. Okay. All right, I would like to call Johnny Chappell.
You state your name and address for the record, please.
Sure, it's Johnny Chappell, 910 Tryon Hill Drive, Suite 100 in Raleigh.
Do you swear or affirm the testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, good afternoon, Mr. Chappell. Can you please tell the board what your relationship to this project is?
I am part of the ownership and development group.
Okay, and can you also explain what your job is, what your company is, and what they do?
So the company that is part of 908 Williamson LLC is Concept 8 Holdings LLC. That's a development company that I have a partnership in, and I'm also a licensed real estate broker.
Okay, and what kind of work does your company do?
We do primarily infill, townhome, duplex, and single-family home subdivisions, primarily in Raleigh.
Okay, and so you have done a number of other infill townhouse subdivisions under the missing middle, or have you done some?
Yes, we have.
Okay, and did you do some of those types of projects before missing middle 1.0?
Yes, we did.
Okay, infill townhome.
Yes.
projects. And those were primarily in the R10 zoning district,
We've done some in mixed-use
Mixed-use,
subdivision, but
yep.
yes, primarily.
mixed use in R10. Okay, when you do a project and you file an application for either a subdivision or site plan, what is the process that you use?
Can you restate that? Sorry.
Yeah, if you're getting ready to undertake a project and you need to do a filing with the city of Raleigh, what is your process?
Our process starts well before we get to the application with the city of Raleigh. Mr. Meadows, who has testified already, is a member of our team. And so one of the fortunate things I think that we have that hopefully allows us to do reasonable and successful development projects is that we do have in-house civil engineering. We have in-house general contractors, my partner as well. And so we're able to, I guess, vet a lot of the projects early on to make sure we believe they will comply with the city ordinances that we are set to comply with. So a lot of the work that we do goes in before we even submit the plan.
Okay, and as far as whether your plan complies with the UDO or other city provisions, is it the engineer who deals with that?
Primarily, yes.
Okay, and your engineers, Mr. Meadows, is the one who makes the filings with the city of Raleigh
That's correct.
and talks with the city of Raleigh as necessary?
That's correct.
Okay, I don't have any more questions. I'm going to turn Mr. Chappell over to Mr. Birch.
Thank you, Robin. So, Mr. Chappell, you were starting to, or kind of went through, once you had identified a site, kind of what your process was, and you mentioned that there was a lot of work that went in to it before actual filing. What type of work, do you do before actually filing a subdivision plan or site plan?
Sure. We were introduced to the project actually in 2021. May of 2021, I believe, was the date. And we looked at the project, or looked at the site for the project, and worked with our team internally to determine what was the highest and best use for the development, knowing the rules that were in place and the missing middle guidelines.
Great. And as a part of your work, even before filing plans, is part of your work reaching out to neighbors in the area?
In this case, it was. We have probably spoken with at least 20, if not more, of the neighbors in the Hayes-Barton subdivision. I've personally been able to meet with in person a number of neighbors, including some of the appellants.
Great.
I'm sorry, including the appellants.
And so the appellants, it's really kind of three owners of three properties: the Bennett's, the Posts, and the Solicks. Here today, are you able to identify any of the appellants who are here?
I met with the Bennett's, and that's the only group I've met with of the appellants.
That are here today?
Yes, sir.
Okay. But you also met with Solicks?
I believe members of our team have
Yep.
spoken with all of the appellants, yes.
Great. Now, with the Bennett's specifically, and working with them, again, even prior to filing, even maybe prior to when they purchased the house, did you have a conversation with any agents related to that property at 1517 Iredale?
Yeah, so in April of 2022, I had a conversation with the listing broker for the property, so the seller's real estate agent. She called me. Her name is Judy McCreary with Fonville Morrissey Real Estate, and she called me asking what our plans were for the 908 Williamson property that is adjacent to the Bennett's property on Iredale Drive. I communicated to her at that time that while we had not submitted it yet, our plan was to submit a subdivision for 17 townhomes on the lot. I subsequently talked to the real estate agent that represented the Bennett's on the purchase. Her name is Catherine West of Berkshire Hathaway. She said that she had clients that were interested in purchasing the home. This was in May of 2022, and asked me if I could disclose our plans to her, which I did at that time, disclosing the plans for the 17 lot townhome subdivision. So that was about a week exactly before the Bennett's made an offer to purchase the property, which occurred per Triangle MLS records on May the 17th of 2022. They subsequently closed on the property in July of that year for, I think, $1.685 million.
Mr. Chairman, just for the record's clear, I don't understand the relevancy of this testimony at all in terms of standing or the merits, but so I'm just objecting for the record, relevancy.
Okay.
Mr. Chappell, I think well, we'll get to it. Even after you filed initially, and even after the Bennett's closed on their property, did you have conversations with the neighbors about the subdivision plan?
We have had conversations with many neighbors about the subdivision plan and probably had, I'd say, between 7 and 8 conversations with the Bennett's, including multiple phone conversations and at least 2 in-person meetings.
And what was the topic of those conversations, if there was a primary topic of those conversations?
Mr. Bennett initially reached out to me to ask for some detail on the plans that we were preparing to submit, or had submitted at that time, excuse me, and he identified himself as a real estate developer himself who'd recently moved to the neighborhood, indicated he had no issues with our project, but would like for us to meet to talk about essentially how we could work together to establish some kind of a buffer between our property and his property.
Right. And that buffer's been the subject of a lot of conversation today, which I know you've heard. How long did those conversations last, and when did they end?
Between September and December of 2022, we had multiple phone calls and meetings. Jason Meadows, member of our staff, I know, and Lewis Hardy met with the Bennett's on their property once, and then I attended a follow-up meeting with the Bennett's in October of 2022, where, again, the primary purpose for the meeting was to attempt to work together as good neighbors so that they felt good about what was being planned next door.
Right. And so, Mr. Chair, just in response to Mr. Justice's objection on relevance, again, I wanted to get some information in on that buffer and the discussions around that buffer. Again, we've spent probably 6 or 7 hours today talking about the buffer between this property and the Bennett's to the north. So that's why this conversation is relevant. Great. And sorry, Mr. Chappell, if you could, I may have missed the answer. When did those conversations about the buffer cease?
Like I said, we had multiple conversations between September and December of 2022. The last conversation we had on site was in October of 2022. We left that conversation our group offered to have our landscape designer meet with the Bennett's landscaper to try to come up with some solutions, whether it be fencing, a wall, additional vegetation, to make the property buffer, if you will, between the two properties a win-win for both parties.
Mr. Chairman, again, I won't interrupt again, but this is a continuing objection to the relevancy of this. It sounds like compromise or settlement discussions, which obviously are not any remotely relevant, but I'm pretty sure my client didn't do anything to change the plain meaning of the code. I assume this gentleman didn't do anything to amend the code either, so I don't understand how this is remotely relevant. I think they're just trying to paint some emotional picture here, which has nothing to do with my client waiving any rights or the interpretation of this ordinance. So it's totally irrelevant.
Mr. Chair, this is background, right? Background information is allowed to help give the board context. 2, we've already sifted through multiple emails today, of which had no bearing on the city's ultimate decision and what we're talking about here. So this is just as relevant as what we've discussed all day long. Mr. Chappell, I've got one last question for you. Again, you've heard a lot of testimony today and arguments from opposing counsel about how important the transitional protective yard is. Not the perimeter lot, but just how important landscaping and buffering providing that B1 or B2 yard is. And so, want to ask you, would you be willing to add that type 1 or type 2 buffer in the event that they drop their appeal?
We were willing to add it in essentially in our meetings of late 2022. And so, yes, we would still be, I'm all about compromise. And so we would still be willing to try to reach a compromise there if the other party would agree to. The way we left it after our last meeting was that we would reach out to set up a meeting between our landscape contractor and their landscaper. That was in December of 2022. And then we got notice of the appeal after that.
Great, thanks. I don't have any other questions.
Nothing from me.
Mr. Justice, you have an opportunity here when you're ready.
Yes. So let me be sure I understand. You had these discussions about what you were willing to do, but in terms of changing your plans from the time of submittal to today, you haven't changed your plans in relationship to anything my clients may have said to you, right?
No, they ended that discussion by filing the appeal. Yeah.
They ended the discussion claiming there wasn't a sufficient protective yard, and that stopped you from considering going back and complying with B1 or B2?
I don't believe we're out of compliance.
Okay. But nothing my client did prevented you from submitting an alternative set of plans that actually would put in a B1, B2 compliant buffer, right?
I don't believe so.
So you said you were a developer, infill developer. I wrote down duplexes and single-family homes, and then you mentioned townhomes. What is your definition of a townhome? Is it a duplex or a single-family home?
No.
All right. So, but you said you were a developer of duplexes and single-family homes. You're also a developer of townhomes.
I said townhouses too.
Okay. So, in terms of how many properties in the city of Raleigh right now do you have your hands in as it relates to townhome development?
Current projects or past projects?
Well, let's just deal with current projects after the Middle Housing 1 changes.
I would estimate somewhere in the neighborhood of 400 homes.
400
units,
homes.
yes.
And how many of them in R4?
To my knowledge, 908 Williamson Drive is the only one in R4. We're currently looking at other properties, but we don't have any that we're moving forward on at this time.
You're currently looking at properties that are zoned R4 for townhouse projects.
Pending the result of this case, yes.
Pending the result of this case.
That was a joke.
Pending the result of this case and whether or not the compact development option is viable.
I think a lot of what's going on with our work has ties to the results of this case and the associated lawsuit. Yes, sir.
So the consequence of this board's determination is not just this case, but it affects other townhouse projects that you are looking at to do in the city of Raleigh.
Yes.
And are you looking at doing any in the R2 district?
Not currently, no, sir.
Now, how many in the R4 district?
To my knowledge, maybe one other at this time.
Did you have any experience before Middle Housing 2 in doing a compact development?
I don't believe we had done one before.
Had you had any experience in doing a conservation development?
I do not believe we've had done one on our development team, no.
And I'm assuming you didn't do any townhouse projects in R4 prior to Middle Housing 1, right?
I don't believe so, no.
Did you ever meet with the city staff personally about this project in the development review?
Personally, no. I believe members of our team did.
I understand. I'm just asking, were you in the room at any point in time?
No, sir.
Is there a reason why that's the case?
Because I implicitly trust the members of our engineering team to take the lead on those issues.
Did you ever email any member of the city relating to this project?
No, sir.
When did you buy this property?
I believe it was December of 2022.
December, before the development approval?
It was around the same time. I know it was in December.
Well, the development approval, December 30th, so did you buy?
Good chance it was before that, yes.
Those are the questions I have.
Thank you. A redirect? No? Board members, do you have any questions for Mr. Chappell? No?
Thank you.
Thank you, Ms. Chappell. Okay, Ms. Tatum, you said you wanted to do one, very expeditiously, one has been completed, and you want to hold your others.
Yes.
So then let us adjourn this meeting, and then we can spend a couple minutes talking about calendars if there's anything that can be resolved now with all of us. No, with respect to Mr. Gordon not being available, we may not know his calendar, so we don't want to presume that. But so we're closed for the day. And thank everyone for your patience. We're done with you. Yes, ma'am. Thank you. So before